right. Good evening. We are back. Good evening, good morning, good afternoon, good day, wherever you're tuning in from. Happy Friday to everybody, regardless of where you're tuning in from. Because it's Friday, it's been another week. So let me know where you're coming in from, what you guys are drinking, if you have some popcorn in front of you. You know, we're going to have a fun time this evening. We're going to have a lovely evening. No drama, no nothing, just fun. But first, we're going to make a way to make this display less obnoxious in my eyes, to turn down the display brightness, because my God, this thing is bright as F. I tell you, man, every freaking time. Come on, you can do this. If this computer, I swear, and I swear, that's not my line. That's his line.
And I swear by the shadow thing to your eye.
I knew that when I started singing that, you would be singing that too. I just knew it was happening. I'm a savant.
Together never apart, and I swear.
Oh, it hurts my soul, but it's wonderful. Why can't I do the open the app? Open the app. Don't do that. There we go. Because all I'm trying to do is make the brightness a little bit less bright. There we go. That's fine. There, less abrasive on the eyes. Okay, good. Hi, Kurt. How you doing, buddy?
It is a beautiful day over here in uncivil law land. How about you?
I'm doing okay. We have a traveling Canadian. So can we bring in the traveling Canadian?
No, I don't like him.
Oh, okay. Here's the traveling Canadian.
Are you what now?
God, the audio is so terrible.
No,
Ian,
it's
I'm gonna leave you. You're gonna be on here for like 2 minutes.
Yeah, I'm just in a cab, and then I'm gonna have to duck out afterwards. So that, the audio is gonna be awful. It just is what it is.
It's fine. It's fine. We can manage with it. Hey, I have a fidget pen now. Ready? It spins.
Excellent.
It keeps spinning. It doesn't stop. It's
Okay,
really cool.
You spin me right round, baby, like a record, baby. Right round, round now.
Exactly that. Exactly
Okay.
that. And it's still going.
These has bad association.
These bearings are smooth.
German bearings, the best bearings.
Love you, Kurt. There's some love for Kurt. Runkle, where are you headed, buddy?
I'm in Ottawa. I'm here for a conference. So, Ottawa for a few days, then back to Edmonton.
You got a speaking engagement, right? And they gave you like a good window of time to speak in?
Yeah, tomorrow I'm on at, I'm going to miss that last half hour of Lawyers and Dragons.
All I know is that Canada's country is currently invading the United States with its smog and smoke and turning the skies of New York and the entire Northeast yellow. And I take it as an act of war, and I think we should attack Canada.
Oh yeah. They'll totally be able to fight us with all the firearms they have taken from their citizens.
Yeah. Oh, no, yeah. We're definitely going to be in trouble fighting Canada.
Oh, God. This is terrible. It's terrible. We're off to a good start, guys. We're off to a good start. Wonderful start. Oh, Lordy. Let's see if we can't catch up with some people in the chat saying hello. There's a traveling Canadian. Say hello. Welcome to Ottawa, Ian. Welcome to Ottawa, Ian, indeed. Hi, Kurt and Runkle. Thank you, Nicole. Kurt will like him when he gets spicy. Yes, Kurt likes it. Oh, all the daddies together. Oh, God, that's a statement. That is a statement. Happy Friday, everyone. Megan Runzer. Happy effing Friday. Drinking a pineapple most that just came inside from planting 75 trees. Wow. Cheers from Northern Alberta. Cheers.
Are those the trees that are burning? If so, are you contributing to the problem? Are you part of the war effort? Are you trying to attack the United States by planting trees?
Oh,
Megan is an enemy operative.
Oh, Lord. Truffle Hound is in the house. Thank you, Truffle Hound. Good afternoon, Robert. Thanks for joining us. Thank you for being here, Truffle Hound. John Carter, go Nats indeed. Go ho Shane, which tree you identify by its bark? The dogwood tree, which is actually the state tree of Virginia, the flowering dogwood.
Also, the state flower of Virginia.
Yes.
Mm.
Braxton Heaps, thank you. Working on my AI in Utah with a strawberry lemonade monster. Just don't do any court filings with that AI. You should be good. Because
Well, you might want to check them first.
you might want to. And the courts are now just requiring attorneys to just certify that they have double checked their AI because that's now a thing. Oh, it's a weird world. So I announced the docket for this case. Oh, no, I wanted to show something else. I learned a new trick on the CNC.
It's pretty fire. It is fire shit, dude. That's pretty fire.
Acrylic with like a light in the base, so it lights up the little logo etched in. That's kind of neat, right? Like you learn new stuff. It's kind of cool. So now I just have to make like a million of these for all.
It's got a little LED in the base to change the color.
I can't change the color yet because this one has like little battery pack. But this is just the prototype.
Oh yeah, no, you gotta get an addressable light strip in there so you can change it. That'd be cool.
I know. I am now like this is a proof of concept, and now that I have proven the concept is feasible, options are like limitless, but it's fun.
Well, as the man who helped you choose your logo, I think that I'm entitled to one as a royalty. So
that's fair. That's fair. I think they got to make logos for everybody.
Well, not so much Runkle because you know.
Kind of awful.
Put this down. Don't fall. Stay still. Okay. Oh, wait. Camera, come back. I'm back. Yay. Diana B. Rob, have you gotten over the Spidey's EDB affair? I may have run away to Florida and done something foolish. Like just but
I wouldn't say it I wouldn't say it that way.
No, I mean you were there.
Yeah.
It was a pretty ceremony though, wasn't it?
It was really nice. I mean, you know, for putting it together as impromptu as you did, and I didn't know that you were going to talk about it publicly at all, to be honest. So I didn't want to bring it up till you did, but it was a really lovely, small, nice reception, and it was a lovely reception. I appreciate it. Simple, classy, not overdone.
And you enjoyed the open bar. We all did, and there was karaoke.
As one does. But let's not talk about what happened after the open bar. That's not fair.
Karaoke station, that was fun.
Yeah, but, there's rumors of film going around, but I hope they're not true.
I really, it would be a shame. And Ian just didn't get an invite, so
no, because yeah. Well, I mean, it was a last minute thing, Runkle, and you understand how this works. I mean, it was short notice, and
I mean, you don't think I'd have made the trip?
We thought, well, we knew that you have all this firearm stuff. We just assumed you were busy.
Oh yeah, you're too busy. You had your thing. We didn't want to disturb you, buddy.
I would have brought the knife.
Yeah. So no, and no, Kurt was there as a guest, not as the other part. Yeah, Kurt was there as a guest. Yeah, but also no, I was just on the beach chilling. So relaxing. That was kind of a troll back to the chat. I saw you guys chatting before we got started, so I figured I'd play a little game. But yeah, Diana B. Yes. Equality. Hi, Rob, Kurt, and Ian. Unfortunately, I can't stay tonight. Have a wonderful FNF, everybody. Indeed. Thank you, Equality, for popping in and saying hi. I hope you have a great evening. John Common. Why must a Canadian ENTs wage meteorological warfare on New England?
Chemical warfare. That's been banned for a long time, but Canada isn't beyond it.
Well, you never know. You never know. I mean, those trees are going nuts. Susan, just wine. It's raining out. Enjoy the weekend. Susan, yes, we will. And I think, based on the profile, I don't know if you're Susan Ferrier or not, but I got a gift that I have to open at some point in time. It's kind of funny. Nick Gloss, thank you, my friend. New Jersey woman pregnant by her AI boyfriend was a news story that brightened my day yesterday. Go AI, knock him up. Ho, that was a whole sentence that I read out loud. Huh. New Jersey woman pregnant by her AI boyfriend. Okay. I guess that's a thing now.
I have no further questions. I'm good.
We're good.
Oh, by the way, did you see? I don't know if you have it in YouTube or if this is a slow rollout, but like 2 days or 3 days ago, there's a new tab in the chat for creators where it used to be top chat and live chat. There's a new tab for monetized chats, so you can see all the super chats and membership chats in one place inside YouTube.
I did not see that. That's awesome.
So I don't know
Hopefully,
if that, I don't know
StreamYard.
if you I don't know if you have that or not, but I just thought I'd ask.
Hopefully, StreamYard will. It does. So on my YouTube channel, it shows me these things.
See, there you go. So now it's all in one place.
Wow.
So it makes your life a little bit
that's
easier.
cool. Now, here's the trick. Is it going to keep it around for the whole time?
I think it only saves the last 100 or something, but
All right. So I might as well.
So for you, maybe.
Then I should call these out. So Amber's Journey, thank you for the gifted membership. Barney Cat, thank you for the gifted memberships.
I gotta go, so I'll see you guys later.
See you.
Bye.
Have fun. And that was a delightful,
you and me
delightful
together.
joining. Ange Torres, thank you for the gifted memberships.
You and me, Rob, together forever. Why must our distance separate us, Rob?
Oh, because every now and then, man, distance is it's a thing. I don't know if I like it though. Joshua, thank you for the gifted memberships. The problem with going to the YouTube chat is it's on the delay again.
Yeah, well,
Kiska,
it is another avenue to see things. So I brought it to your attention. I'm here to help.
Member chat from Kiska. Woohoo! Friday, finally Friday drinking Chiltons as always. Wonderful. Neurodivergent counselor, thank you for the gifted memberships. Lynn, gifted memberships, thank you very much. Jessica P, thank you for the member chat. Yay, 8 p.m. Rob Standard Time, RST. Yeah, I know. I was only like 6 minutes. KC Cat, it's your birthday. Let's party. Happy birthday to you, KC Cat. I hope you have a splendid birthday. Alessia, my favorite way to spend Friday nights. Thank you. Super Susan, really appreciate you, Rob. Happy having a Pepsi in Oklahoma. Wonderful. Crazy by Proxy, good evening, everybody. Good evening to you. Equality with gifted memberships. This is a really cool tab. Eric Newman, you guys are awesome. Thank you very much. You're awesome as well for being here. Tony P, Law Daddy Stacks. That's a fair statement. I think that's awesome. Brentwood Chic, thanks for the gifted memberships. And Kathy Trout, thank you for the gifted memberships. Awesome. Awesome. Okay, Susan. Yep, not sorry. Okay, so now I have to roll out what Susan gave because this is fun. So it came in this little package. It was beautiful. It was ribbon worked. It was ribbon sewed, and inside said package. I was going, what the hell is going on? There's a lovely card. Very lovely card. Thank you so much. Very beautiful. Very, very well written. And then I went inside. I was like, what is this? Like, are these earmuffs of some sort? They're not. It's a crocheted.
Oh, it's a crochet oyster. That's cool.
It's a crocheted clam.
Okay. There's a pearl inside. Do clams have pearls?
I don't know, but I think it was a joke from Linda's Tight Little Clam Needs Loosening.
It has a pearl inside. It's an oyster.
It's an oyster. But I don't know what this part is for. I'm not going to guess, but it's Linda's clam. And then the coup de grace, which I just about died. You're going to get a kick out of this, Kurt. I have to shut my camera off for a second.
Okay. While Rob is putting on some sort of costume that I'm sure will rival the unicorn hoodie, I'll just kindly remind all of you guys, because Rob doesn't mention enough, that you should make sure that you're still subscribed, because YouTube does have an unfortunate tendency of subscribing and unsubscribing people apparently at random. So are you subscribed? Are you sure? Please make sure to check that subscribe button. And while you're at it, why not give this video a like? Because you're here and you obviously like it. Give it a like and help support my good friend Rob.
Kurt, that was very sweet of you. Thank you very much for doing that, because I do forget all the damn time. It's ridiculous. Just as ridiculous as the lion hat.
Well, It is Pride Month.
Oh, it's a pride hat. It's pride hat. That's funny. I have a lion mane.
Okay.
This is the wildest thing, but it's actually really well stitched. Look at the stitching. That's on that side. That is really funny. I will actually wear this. I don't know where, but I will. So, Susan, who apologized for nothing, you don't have anything to apologize for because I now have a lion's mane. It's awesome.
Keep it on. Keep it on.
Maybe later, bud.
Wear it in court.
Wear it in court. Wear it in court. Wear it in court. No.
Could be good with a child witness. I don't know.
But I could, like on winter months, like wear it into the courthouse. Just throw everybody off.
I see it. No. Yeah.
It's a Gryffindor hat. Oh, Gryffindor hat Koluna. Oh, yeah, I am a Gryffindor. That's awesome. Okay, I'll take that. That's great.
Okay.
Chad is great. Chad is fantastic. He's fluffing the mane. Oh, God. I love it. This is great. Oh, no. Spank the Mumpy lends a hand puppet show. Okay. Yeah, maybe. Okay. I get it. That makes sense. That's for the members only stuff. We read books that are funny. Like Brenda's Beaver Needs a Barber. Peter Pitches a Tent. Tiggle Wiggle Pickle or Pickle Wiggle. I forget the names of all of them, but they're all there. So yeah, I think judges might object to me wearing that in court though. What was the first dance? I don't know, Kurt. What was the first dance?
I don't know. I got nothing here.
It was probably I Swear.
Yeah, that works.
Yep. Go Shane. Don't worry, Ian. We weren't invited either. I mean, gotta keep some of these in private. Braxton Heaps, I've been thinking about training on AI, on U.S. code and case law. What are your thoughts on a law GPT? What should I make sure to include? All the disclosures. Literally.
That'd be interesting if you could like train a ChatGPT on court decisions in order to help write things in a style that a court would write them. That would be an interesting training set.
And you know what's funny about that is LexisNexis and Westlaw they're both rolling out AI assistive writing materials to assist you with motions practice. And I wonder if they're going to have to completely revamp everything they're doing based on what the courts are doing now, which is kind of saying,
Lexis is going to cite cases that actually exist to get that going for you.
That's probably true. Yeah. But Braxton, what should you include? All the disclosures, like every disclosure known to man. That's probably a safe place to start. Let's go, Brandon. Did you hit the wine yet? No, but a cocktail.
I'm thinking about it right about now. I've got a couple of bottles that could be opened.
I've got Lawyers and Dragons cocktail, a gimlet that's just delicious.
Yeah, they let you be a series regular, Rob.
Hey, buddy. It's a new series. We're learning about it. We're growing. JR, did you get any rounds in Florida? I did not get to play golf. I need to play golf. I have golf scheduled this week. Time Lords, thank you very much. Happy Friday.
Golf is overrated. I like to always...
False. It's not overrated. What do you mean it's overrated?
No, man. I'd rather go up to Wolf Trap and let's do some skeet shooting or something.
I mean, skeet shooting's fun.
Yeah.
But yeah. Morgan LaRusick, your FNF stream makes my week live or on replay. Thank you very much, Morgan. I hope you have fun. Susan, you said, yep, not sorry. Not asking for an apology. You did great. I love it. Mousy Girl, thank you for the super chat. So on the topic, what are you on? I know that I had a docket item ready.
There are many things that happened this week. The Supreme Court released a couple decisions, including one that kind of blew my mind from a purely technical legal level. That was weird.
Which one was that? The Alabama?
No, it was the one dealing with what counts as identity theft.
Oh,
because the Supreme Court explicitly said they were using the title to help understand the statute's text. And I was like, what?
Which is contrary to everything they've said in the past. Usually headers and titles
apparently it is a commonly used tool that helps to clarify issues. We use titles all the time in interpretation, apparently. It blew my mind when I know. It blew my mind when I read it. I couldn't quite deal with it.
Like, no, since never. The Supreme Court's never done that. We don't use titles.
No.
To
Sotomayor says we do.
Well, Sotomayor says a lot of things that I might not agree with. But we did get some solid opinions. We got an 8. We got an 8-1. It was 8-1. Another 8-1.
Yeah.
Was the union one unanimous?
Yes. Yeah, I think so. I thought that was correctly decided. I think it was 7-2, actually. I think it was 7-2. We got the one dealing with VIP products with the Jack Daniels chew toy.
And they basically said, Ninth Circuit, the test, you applied it wrong. You got to go back, apply a test, take evidence.
Yeah, they said that the special circuit, they said the special test the Second Circuit came up with was inapplicable to this situation, without deciding whether the special test decided by the Second Circuit is right at all. Yeah. But they said it shouldn't be used here.
So I know it wasn't on the docket that I listed, but the Kohberger motion got a little spicy, and I kind of wanted to watch it.
Yeah, I did not see this. I was busy covering other cases today, so I missed out on the Kohberger motion. So I'd like to see this.
So yeah, motion to change the docket. Is there a second?
Yes.
Okay, good. Vote of the chat. You have 2.2 seconds to say yes or no. I see at least one yes. The motion is carried. All right.
When do they get votes?
I don't know.
The
only thing they're voting on is swoop. They just want to swoop. So we're gonna swoop, and we're gonna go to the Kohberger because it was really fascinating, and I think we're gonna kind of enjoy some of the spicy back and forth between the attorney and the judge. Now, a warning: the audio at the beginning is kind of rough, so bear with us. But we're a swoop, and we'll start with the Kohberger stuff.
I'm usually better on timing than that.
That was me.
That was hanging too long.
It was my fault. I kept you hanging way too long on that, and that's completely on me. So let's do the screen, get into.
Oh yeah, sure. I'll push the button too. So I'll do a swoop there too. Okay, great.
Push button.
Yeah. Speaking of which, weren't you supposed to come up with a swoop for me?
Dang it, Kurt. Thank you for reminding me. Where's my? You know what? I have a pen to write this down with.
So he swoops. I push the button.
Swoop. Push the button. Push the button, swoop. Push the button, swoop. Paper. Notepad. Push the button. Swoop. For
bee fish of some variety would be appreciated.
Bee fish.
There you go.
Swoop.
Western bee fish.
Okay, Western bee fish with cowboy boots.
Yeah.
Cowboy boot and hat, bee fish.
Shotgun would be fine. Yeah, that's a good idea from chat.
We're gonna go with that. So
great.
Let's go ahead and roll into Kohberger. Share the screen. Go to the tab, and let me know if you can hear audio.
I can.
Good.
Can you turn on closed captioning, please?
Yes.
Thank you.
Oh, judge forgot something.
This is an interesting way this courtroom is set up with the judge's bench all the way on the wall like that.
It is. I don't like the corner.
Kohberger looks good in a suit and tie.
I appreciate the fact that they let him dress out, and I think that's the appropriate thing to do, especially if you're going to allow media in the courtroom.
Yeah.
This is a small courtroom.
Yes, it is.
Oh, that's embarrassing. That's not me. That's in the court.
Your call is important to us. Please hold, and the next attendant will answer your call shortly. Your hold time is 53 minutes.
The size of the courtroom. I actually want you guys to think about this, because what we're hearing about is the gag order, and the judge wants to hear specifically about whether Casey Gonsalvez's family is subject to the gag order, and also has Well, we're going to get to that, but also has expressed discomfort with a lot of the media presence. And I want you to bear in mind that this courtroom is that size. There is national interest on this case. And if a courtroom that size, if you can only fit that many people in that courtroom, they need to have a way of actually allowing the public to meaningfully watch what's going on. And I want you to kind of think about that while you're watching what's playing out here. Eventually, when it starts. Again, eventually. The lawyer's supposed to do that. That's actually pretty standard. The party in motions sits the furthest away from the podium. This is the audio. I'm sorry.
A ThinkPad? Who has a ThinkPad anymore?
I don't know.
How old is his laptop, man?
Syracuse Brad, we are watching the Brian Kohberger, the Idaho 4 case. This is the gag order. So there was a gag order issued in this case that precludes any of the parties from speaking about anything about the case while this is ongoing. And it precludes the dissemination of information that is accessible to the parties from being disseminated outside of those parties. There are third parties, not party to the litigation, who wish to speak publicly about the investigation, about facts that they believe they know, and engage in their First Amendment right. The court's not really enjoying what's coming out, and there's been a lot of criticism about the reporting on this. Some of it's completely fair. The people that are saying that he looks like a creep and that he totally did this and all this other stuff, this is way early in this case. This is not he does not walk into this trial presumed guilty. He walks in presumed innocent.
Yeah. I don't think enough information right now that's available in the public consciousness to adjudicate guilt.
And there's a lot of irresponsible people that are going out there and adjudicating guilt ahead of time.
Yeah.
That's not what we're doing. We're talking about whether or not people have the right to communicate the facts that they know or communicate openly about the case while it's ongoing, and how that balances against the defendant's Sixth Amendment right to a fair trial.
Well, the judge has no authorities to non-parties. That's the bottom line.
He starts to assert it, and the back and forth is pretty spicy. You're going to enjoy this part. You're going to enjoy some of the dialogue.
Okay, like, screw you. Let's get on the record, please. How can you bind me when I'm not a party? Where's my due process?
He gets there, and they start to bicker.
State versus Brian Kohberger, CR.
Well, Uncivil Law Court of Appeals is ready to step in.
We're here for a hearing.
Do I have to write an amicus now?
Resolve this
Might.
family's motion to appeal, amend, and/or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine.
The audio gets better, but let me.
And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is.
Let me sit back here, Your Honor.
And I believe.
Is that better?
Yes, much.
Some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonzalez family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of names, Kaylee's name and Zayman's name. And I want to explain that. I was up all night, really ill.
How about I'm human and I made a mistake?
Poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names.
I'm sorry for the mispronunciation. Would have been fine. You really didn't have to put an explanation about it.
My apology for that. I know some people were concerned about that and wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right.
Yeah.
And under Rule 11A1 of the Idaho Criminal Rules, this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty.
Right.
That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain
It's not
that.
common in any court I've ever heard of, so maybe it's usual in your court, but it's not common in courts I've been to.
It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public.
Oh my God.
The processes that
You're going to educate the public through a gag order? Is that what you're doing? Okay. Feel educated.
And that's important for journalists. That's also important for the citizens. So if you're curious about that, you can always.
No, I'm going to keep talking over unless Rob stops me. Thanks, though.
On the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today.
So one, I cranked the volume on that tab, so hopefully it comes in a little bit louder, and I turned us down a little bit. Two, that's my speech for today. Judge, I understand you're concerned. I really do. You don't get to pontificate like.
Just do your job.
And your pontificating isn't really a ruling. It's just an observation of what you wish the ruling was. So there is going to be commentary. That was nothing of value. So
and also the subtitles are right there for you to see.
Exactly. When the attorneys are arguing, we're going to listen to the attorneys argue, and we're going to listen to the back and forth because we don't want to miss what's going on in the back and forth.
I might snark at it.
Yeah. This judge, the pontificating from the beginning, I'm not really a big fan of that. So let's see how the attorneys handle it, because already the judge is showing aggression towards what the judge is or is not going to allow, which isn't really reading well for the Gonzalez family. Yeah.
Mr. Gray, come on up. And
if you allow me just a minute or two to get sorted out here.
Take your time. Thank you, Mr. Gray.
And the audio does get better, by the way. At some point. I forget when.
Can I proceed, Your Honor?
Yes.
Are those tennis shoes?
No, they're just brown dress shoes, I think.
Okay.
With a white sole. It's weird.
Okay.
First, Your Honor, we'd like to thank you for apologizing to the victim's family.
No one cares.
I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification.
I think that was a misstatement. No, the attorney didn't misstate it. I think the judge overstepped in that.
Yeah.
When the judge says all interested parties,
No, that doesn't make sense.
the judge
I
doesn't
don't
have.
I don't know,
legal
strictly
bind
speaking,
them.
legally, that there are any interested parties.
And that's
I'm not sure the victim's family technically legally are interested parties.
And that's the interesting part about this is the interested parties argument, because this is an action against the only interested parties are the state
Yeah.
and the agents of the state, the defendant and counsel and the agents of counsel. Those are the parties the court has the ability to bind.
Right.
And the court has the ability to set conditions on people that are, broadcasting or appearing within the court.
Yeah. And he also alluded to the rules of ethics. He said Rule 3.6. There's a standard rules of ethics, which basically prohibits a lawyer who is acting in a case from communicating outside the case in a way that would prejudice the case. And so that's also right. So if I am going to communicate to the media, I have to do it in such a way that will not influence the case. So there's that. And then also as a party to the case, or the attorney to the case, I have information that is not necessarily available to the public because of discovery. And that information is going to potentially come out at some later time. But if it comes out early, it could mess with the process because it's supposed to come out in a regulated way pursuant to rules of evidence. So that makes sense. And also the attorneys before the court, because they're officers of the court, that also makes sense. But the interested parties, whoever that is, I don't even know who that is.
It's way too vague.
No.
It's way too vague. You can't enforce, you can't create an entire, because this is what this is it's a prior restraint on speech.
Yeah, it's prior restraint on speech to a non-party who doesn't have due process because they're not there to object.
And they're not permitted to file a motion.
Yeah. So
it's a very curious position the court is placing themselves in.
Yeah. Court's wrong.
They were when they did that, I think. I think it's curious going forward because and the person that's speaking, because someone I saw in the chat who's talking, this is Shannon Gray. He's the attorney for Casey Gonsalves and the family. So not the state, not the defendant, third party.
Yeah.
I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting.
Yeah.
As well as if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared. But only having a 3-hour notice to allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd, and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this
Which
case,
I still don't know who that is.
including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action.
But that presupposes that witnesses are interested parties, which they're definitionally supposed to not be. Witnesses are not supposed to be interested parties. Just the facts, man.
So scroll.
They're not.
Pause.
Strictly speaking, a witness isn't supposed to care who wins.
That's what I mean. So I was going to say pause. The definition of interested parties are parties who have an interest in the outcome of the case.
Yeah.
If you have an interest in the outcome of the case. So, for example, I can see some argument that the victims might be interested parties because they have certain rights under the Constitution, victims' rights. They have an interest in the outcome of the litigation. They are the aggrieved persons for whom the state is prosecuting the case.
Mm-hmm.
But a random witness, so for example, a gas station attendant, who doesn't care one way or the other, this order would bind a gas station attendant and the attendant's attorney from saying anything, a prior restraint on their speech, without any connection that would indicate that what would be said would be prejudicial to the defense. Again, prior restraint. So yeah.
Are we breaking the order, Rob? Because we're talking about this. Are we interested parties?
I certainly freaking hope not.
I don't care. He can bite me.
Oh my God.
I'm not in his jurisdiction.
I still practice, Kurt. Don't get me in trouble with judges.
Not in his court, you don't.
That's true, but don't get me in trouble with judges.
Don't make unlawful orders. How about that?
That's a good point. So let's continue on. Let me take a brief pause. Let me pull this down real quick and say hi to somebody who's tuning in from oh my God, my ironing board is in the background. That is terribly embarrassing.
Ladies and gentlemen, he has an ironing board.
He's civilized.
So Alita snuck in. She came back from dinner. Alita is staying this weekend in the lodging house of Law, Lumber, and Lodging.
A place I've previously stayed. Are you enjoying your accommodations as much as I did?
Yeah, it's nice. It's very comfortable. I mean, I will say when you've been traveling for over 24 hours, probably just about anything is comfortable. But with that caveat, it's been really nice.
Yeah. See, so right now, this now tallies up to I've hosted Ian, Joe, Kurt, and Alita.
Yep.
So anyone else that wants to come and crash in DC,
Yeah.
The accommodations.
Anyone
are
else who
fine.
wants to? Because I think some friends of your chat might want to come and crash in DC.
We're gonna limit that to friends that are like I have a collegial relationship with.
Yeah.
How long are you in town, Alita?
Well, I'm in the DC area until Monday, and then I fly to California, and then I'm there until Sunday.
Okay.
Yeah.
When we fly out to California, hang out. This weekend.
California's great.
Yeah, it is great. I mean, it's sad. So this weekend is happy circumstances. My nephew graduated from high school, so we're all kind of getting together and celebrating. Next weekend, it's a little bit. It's more than. It's much more sad. It's for a family funeral. So yeah, it's one of those. So maybe you don't want to come out to California for that one.
Okay.
But
well, I could try to cheer you up afterwards. I guess I don't know. We'll figure something out.
Yeah. No, it's.
Well, I'm sorry to hear that,
okay.
Alita. I hope.
Thank you. But I probably shouldn't even mention it because I don't want to bring down the tone of.
No, you're fine.
Of Friday Night Frenzy. It's a fun.
We're already talking about a quadruple murder, so I think we're fine.
I mean, that's true. That's true.
We're gonna have some heated commentary about it. I'm not in DC from my perspective. I am 20-minute drive to DC. It's pretty quick. I'm not in DC.
The DMV.
I'm Northern Virginia. The DMV. Yeah. Pretty quick.
Yeah.
So yeah. All right. So let's continue with the Kohberger thing because you haven't seen this yet, Alita, have you?
No, I have only very lightly been following the Kohberger situation.
I've picked up on it more recently, and specifically the thing that's getting me more and more interested is how aggressive some of the commentary being made by the parties and the judge on the presence of media, the presence of public in the courtroom. That's where I'm getting very interested. So we're going to see how the judge handles this. And Shannon Gray is arguing for Kaylee Gonsalves, the family, saying, hey, we shouldn't be subject to gag order. Let us talk. We should be able to talk.
Yeah.
You can't bind me from speaking. I know that you're nodding along. I think the judge disagrees, and I think that there's going to be an appeal issue at some point. But let's kind of see.
I mean, I understand why the family feels that way. Why they want to be able to express themselves and talk.
My appeal would be in the form of me saying "bite me" to the judge. That'd be good.
It's a balancing act, and the thing is, I think that you can't just view one amendment being superior to the other. So I don't know.
So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case or any attorneys that might have an interested party in this case. So that's where we are today. I filed a motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then your clients are not parties. The only parties of this case are the state and Mr. Kohberger. That's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families. I would agree. That's well established.
I'm not sure about constitutional protection.
So
maybe the state
let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tap case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahanty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Slav was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall, Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements.
Yep.
That is not me. It never has been me. It can't be me because I'm not involved in the litigation.
Yep.
She also says
Can I ask you a question about
Yep.
that? Because I mean, I think the case law is quite clear that attorneys who are
Is he wearing sneakers in the courtroom?
Can
Yeah,
be
we're something like that.
restricted to
Something
some degree.
similar.
Partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
and I can
issue
address it,
right
Your
there.
Honor.
Let's do, because I have the rule, because they keep referencing this rule. So rule
To the
3.
text.
Trial publicity. This is the rule they're talking about. A lawyer who is participating or has participated in the investigation, so not this lawyer, or litigation of a matter. Again, not this lawyer. He's not participating in the litigation of the matter. It goes to the core of the matter. This is the criminal prosecution. The participants to the litigation are prosecution team, defense team. Shall not make an extrajudicial outside the courtroom statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter.
That's just rule 3.6 of the rules of ethics. That's basically the same in every jurisdiction.
And then there's carve outs. So the first paragraph A, that's the restrictive. Everything else is the notwithstanding, which means they can say all this other stuff. But, and then again, D is no lawyer associated with the firm in governance agency subject to paragraph A. So it's conditioned on A. So again, going back to this, participating in the investigation or litigation maybe by some stretch the witness, but he's not representing a witness.
Right. Because
I wonder if there's some case.
Witnesses.
Is there some case law that further elaborates on it?
He's going down that road, but. And then L. Fliggins, I see your comment here. If the lawyer is facilitating the family's contact with the cops and the state, there's an argument he's participating in the investigation. I don't know. And how far do you cast that net? Because with every single circle outside that first rock hitting the pond, every ripple outside of that, you have to re-engage in the analysis over and over and over and over again. And the further out you get, that First Amendment privilege starts to get more and more important.
Yeah.
So I don't know. And lost in a crowd. Thank you for the super chat. Is it me or is the lawyer reading more into the judge's gag order than he needs to? No, you're going to see pretty quick that the judge thinks that this lawyer is bound over and can't say what he's been saying. So we're just going to continue watching for a bit.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes, because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family, as well as myself. The other thing is that if the victims can say whatever they want during the free speech, and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, I'll give you an example.
Is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the
tone.
I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I asked for clarification, now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, the family has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion?
2 points. Rachel Mills brings this up, and I've seen this in the chat as well. This is a death penalty case. And in death penalty cases, there is, for purpose of asking for the death penalty, there's breath of life witnesses that talk about the significance of the crime and why the death penalty should be imposed. But penalty phase and guilt phase are different.
Yes.
And
the rules are different too.
The rules are very, very different in those regards.
Yeah.
So that should not play into this, because the defense right to a fair trial goes to their right to the adjudication of guilt. Their adjudication of guilt. And then the penalty phase, there's a different set of standards that are in place. So I don't think that that's a basis for him to place a gag, but the judge also said something like very clear. The family is not subject to the gag order. And the judge has clarified that like 3 times. But the family then doesn't have a right to hire an attorney to
communicate the same message.
Well, there's also basically this. I mean, what he's arguing here is this issue of like notice that they would be a witness. Like the court's, it sounds like the court's almost like expecting them to just assume that they'll be called as witnesses, but no one has talked to them about being a witness. No one has talked to them about the investigation. So it's like there's also this idea of like how much can you fairly impose upon them if no one has given them any kind of notice of any of these issues?
This is a good point, and this is state specific. Rachel Mills question. No, I mean if the actual case in trial. This is a good point because George Floyd trial threw me for a loop because in that trial, the judge at the guilt phase allowed breath of life witnesses to testify. And I don't.
Yeah.
That was I believe based on state specific rules that allowed that to happen. I don't know if Idaho has that. But then the judge is also that's the other thing, they contradict themselves. So the judge is also saying they are not the witnesses, the family is not a party to the gag order. So the judge is saying they're not part of this gag order. But then they're saying the attorney is. I'm confused. It really is sounding like the judge doesn't like the fact that the attorney knows how to command the media, knows how to command an audience, and knows how to say the things that need to be that the attorney wants to say. The family, if the family was out there alone without the attorney, they might have trouble articulating a lot of that. And I get that. The family may be witnesses, but witnesses to what? Not the crime.
They're not fact witnesses.
They're not fact witnesses. They can't be. So, and I know you guys are fighting me on this. They're going to taint the jury. I understand all of these arguments, but they are balanced against each other. A lot of this is a lot of weight on one right and a lot of disregarding of another. And you have to actually show that you're balancing both.
Right? Well, then I'm already governed by the Idaho rules
Still hate
of professional
issues.
conduct. And if
I'm glad you're acknowledging.
Can't help it.
Is it because of the last seasons?
Your Honor. I mean, it's not.
No, they
every
look
attorney
way
is.
too casual.
What
Sorry, I wasn't listening. I'm distracted by his shoes.
And I was trying to vaguely allude to a
they
legally
do make
blonde
dress
joke.
shoes now that have white soles. Their dress shoes. Look, I'm not going to comment on the fashion sense of young folks these days.
I
I'm
will
now considering
always
myself.
comment on fashion in the courtroom.
Yeah, that's
we're
fair.
not commenting on the fashion itself, but the judge. You don't need to. Hang on, I'm going to rewind for a second because this is.
So
I talked over it.
Idaho rules of professional conduct.
Hang on.
And if I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is.
Oh, that was a little snark.
I'm
Little bit of
already governed by
sarcasm.
the rules of professional conduct. Well, I'm glad that you're acknowledging that.
You're not in a
hostility
good
here.
place with the judge right now. He's saying that.
Judge started hostile to you, though. I don't know what you did at
did.
this point.
It just feels hostile all the way around.
Hey, Judge, have you heard of the First Amendment? It's new.
It's
Not that new.
you
I was going to say it's not
engage-
new, but then I'm like, from the perspective of some people around the world, it's relatively new.
Well, you can engage in a back and forth that's contentious without getting to that.
Yeah, that's a little sarcastic and kind of snarky.
And what's funny about that is I think that leads to some of the more contentious argument that we start seeing.
Your Honor. I mean, it's not every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the trial publicity. But the trial publicity, I don't even think applies to me in this anyway, because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this. Rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you
I think he's
think
right.
you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that
I understand
the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court
We should invite
want
this guy on to Friday Night
victims'
Frenzy.
families to have representation, to guide them through the legal process? Wouldn't the court encourage that? That they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families.
They
And
must
I have
decidedly
not seen
Not really.
They're most decidedly not representing the victims. We know that all too well from so many cases.
Not really. No, they're representing the state.
Yeah.
The
Yeah.
state has an interest in like, here's the thing. Prosecutors don't represent victims. And
No.
this is something that is going to catch heat when I make that comment so broadly. They don't represent the specific victims. What they represent is the body of individuals, the body politic. They represent the state. The state has an interest in ensuring that its citizens don't get murdered. Therefore, they prosecute the murderers of citizens of the state. The interest of the prosecution isn't those specific victims. It's to make sure that no more murders take place in the state.
Yeah.
So, and yeah, Emily was a prosecutor and she said we represented victims. But at the end of the day, even Emily, when she was a prosecutor, had to answer to her boss and the DA and what charges could or could not be brought and what had to be dropped and what she could or couldn't say in court. And if she said something inappropriate in court, the DA would remove her from the case and come back in and say, we're gonna drop all these different charges. And the prosecutor that was trying the case would have no say. They wouldn't have the right to do that because the state is the body that's there representing, well, the prosecutors are there representing the state. So it's interesting. So a little misstatement by him there, but we'll see.
a poor line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way. It's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know. I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial.
And the other thing,
well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in
No.
that process. of
Not certainly.
sentencing. That's not,
Post-conviction.
that is not post-conviction.
Yeah, not certainly. Not certainly. Not every victim wants to give a statement. Some don't want to. It is by no means certain that they will give a victim impact statement.
I don't know that the judge is right on this. That's not the judge says that's not post-conviction technically.
Yes, it is.
It is. It's sentencing.
Yeah, yes, it is. You get a verdict, you enter judgment. That's conviction. Yeah.
And Griggsy made a point here that I wanted to kind of bring up. You're 100% right, 100% wrong. Victims complaining witnesses include the state. The victims are a part of the state. Specific law, Victims' Bill of Rights. Victims' Bills of Rights varies by state to state. Not all states have them.
Mm-hmm.
Yeah.
And they're statute specific. They're voted on by the state.
And even I am aware of no victim's Bill of Rights anywhere that would allow a victim to dictate to the prosecutor. That's how you know that they're not a attorney for the victim. Because if they're my attorney, I can be like, drop the case. I know of no victim's impact statement, no victim's rights statement where they can be like, you must prosecute. You cannot accept this plea deal.
The number here's the statement. The number of times where a domestic victim says, I don't want to go forward, and the state says, I don't care, I'm putting you on the stand, is a vast majority of cases where the victim says, I don't want to go forward. The state says, I know that you don't want to go forward because of all the fear that you have, but we're going to go forward and prosecute this person.
Right. So, I mean, every victim's right statute I've ever heard of gives a right to be informed about steps, I mean, among other rights, depending, but right to be informed, a right to hear about plea deals, a right to be present. But I know of nothing that gives them a right to intervene.
I have corrected it a couple of times. The chat has corrected it. It's not what I'm saying. Emily's right. If Emily said the prosecutors represent the state, that's the right call. Just saying. If I didn't see it, so just take it easy, okay? We're just watching and giving commentary. It's fair.
Yep.
It's if your goal is fair and impartial jury, right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public,
this is fair,
have particular restrictions. That's what this whole case is about. In this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client.
Regarding the facts of this case, no, they haven't. How things occurred.
Everybody's going to have a chance.
Interesting caveat. What did the prosecution share with them? Anyone catch that? Regarding the facts of this case, they have not.
They might have shared process issues.
Chance to weigh in on this.
I thought he said that they shared nothing. They told them nothing.
You're helping me understand what the issue is. So thank you.
Well, so that's really the issue here. I mean, and it's
like they look red.
Because what you're doing is.
Sorry, Alita. What was the comment?
His shoes are they red? The front of them.
That's fine. That's a style, Alita. Brown shoes and blue slacks and blue suit.
I thought they were brown. I saw brown.
Are they brown? Maybe they're brown. They look, I mean, to me, maybe it's the lighting
maybe
of my computer.
Maybe it's like an oxblood thing.
I get it.
I'm sorry.
It's unfortunate. You know what it is? It's unfortunate camera placement. You know the camera should be? It should be on his face when he's arguing. It should be on the judge's face. Like, I wish it was there.
That's also true. They are. I'm sorry.
Are you sorry?
Disrespect.
Are you sorry?
You know, but this is also why, like, I made the comment, like, I was in a moot court argument and I did great, and the judges were like, great argument, and the last one was a trial attorney that was sitting in, and he said, I love the argument, but I couldn't listen to half of it because I was staring at the gap between your tie and the top of your shirt. And the point that he made was, you're an attorney, like, you might not think it's important, but people notice everything and they get distracted by everything. The last thing you want when you're making an argument is for people to focus on something that's not the word coming out of your mouth.
Yeah. Yeah. I mean, that was one of the things that they you know, when I was in law school doing mock trial, that was like one of the first things that they did is they had people come in and they were like, look, you've got like, no fancy jewelry, like no nothing that's going to like distract someone away from what it is that you are saying and doing, because you can lose a lot that way.
That's true.
Yeah, but again, this attorney's like we are, like I said, unfortunate camera angle. We're seeing the backside of everybody except the judge,
true.
and we're not even getting a good view of the judge.
Judge is sitting in the corner where he belongs.
And by the way, the judge also looks like Kevin McAllister's dad in Home Alone. Like he got older.
I don't like you for saying that because it's so accurate.
And I can't be the first person to point that out. People have been watching this trial for a long time, or this case for a long time.
When they do a zoom in on him, I'm going to be really upset. I know I am.
This has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a
Zoom in there, Rob.
Mr. McAllister. It's Judge McAllister is now his name.
If there is a witness in this trial named Kevin, we are in trouble.
Or one of the lawyers in the case, because he's yelling at him.
Kevin. Oh no.
Kevin.
It only works if it's a female lawyer, though. Yeah.
No, he yelled at him too in the movie.
Did he?
I think, yeah.
Okay, I'll take your word for it. All right, fair enough. I stand corrected.
a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know.
I have been in three arguments in my career where I have made that statement. They were all fun. And by fun, I mean not fun. Because one of them was like, that was the one where it's like, Mr. Morton, you know, you have your toothbrush. It's that kind of stuff. But I agree that the attorney needs to do this. If you're going to make the argument, make the argument. If you're going to say the judge doesn't have the authority, say it. Like, say it. Like, if you have the First Amendment right, you say it. Whew.
Big brass ones. Go broke.
Potion Master Danya, what did he say? He said, I don't think you have the authority. Judges don't like hearing that, and they very quickly respond with, I think I do. And then you see where it goes from there.
No, they've been elevated to the role of demigod. And, you know.
The attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay,
So
that's hard to accept. But
we're not witnesses in the case. We're not involved in the investigation. We're not involved in the litigation. I can't file any motions. I can't subpoena anybody. I can't cross-examine witnesses. I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is.
We're talking about your speech.
That's right.
Not your client's speech.
But that is my speech. That is part of it, though.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
I do.
It's distinctive from.
I feel like I would stay away from that argument if I were the
That's
lawyer
why
here.
the motion is for amending or clarification, because there's the clients that have the free to speak. there's me repeating what they have to say. If they said we thought the judge was crazy, and I said the judge was crazy, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice where I said, the judge is crazy? Yeah, I think the judge is crazy. That goes into another layer, right?
Yes. Okay. This is a good point. And I think the judge glanced over it way too quick. And this is a point like the Depp v. Heard argument, right? Adam Waldman was making statements and giving his opinion and giving all this articulated argument about what Amber Heard was doing. And the judge in that case and the jury was allowed to connect the dots between Johnny Depp and the attorney that made the statements without really making that distinction that the statements could be made by the attorney as an individual who has a First Amendment right. It has been really pretty clearly articulated in various bars across the country. Virginia bar I know did this, that attorneys have a First Amendment right to engage in political speech, to engage in these things. Irrespective of their clients, they have a separate right that you have to acknowledge. So if you're trying to overcome the First Amendment rights of the individuals that are in front of you, if you're balancing those, you have to balance two separate First Amendment rights, the victim's First Amendment rights and the attorney's First Amendment rights. And the judge flew past that way too quick for my comfort level.
Yeah, but I feel like his First Amendment rights are a little bit less, not that they're less important, but like they just seem a little bit less relevant here because he's only but I also very much disagreed with the whole like Waldman decision by the court anyway.
Yeah.
But like he's acting in the role of just kind of being like the representative of he's not and anything that he's saying to the public he's not just like talking by himself, right? He's not just talking on his own. He's doing it for the purpose of representing these other people. So it's like you're not you are the avatar for them. You know what I mean? Like that's just, but I get what you're saying, Rob.
Well, and if his First Amendment rights are separate from his clients, and if he arguably has less access to information than his clients who are witnesses, then what harm does he do that's more extreme as far as the Sixth Amendment rights of Mr. Kohberger than his clients? That was a jump that I didn't want to make. That's an intellectual thought that I am not capable of thinking right now. All right, let's see how the argument plays out.
Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the probability. I would argue that I don't, because I'm not a party to it. I'm not litigated it. I don't have any information on it. None of those things. So really, that's where the authority
this is not as well organized as it could
my
be.
voice would come from the Idaho rules of professional conduct. If I did that, and if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media's outside and they interview him. They say, hey, you're an attorney here. What about the judge being crazy? Well,
this is not well organized. It's not particularly well organized. I don't like the way this guy's arguing the case.
He went sideways on it. It's not about that. It's about his access to information. And he completely sidestepped that. The random attorney that sees the sign and says, this judge is crazy, that random attorney doesn't have special access to information provided by his clients, which are the witnesses in this case. Make that argument, not this random argument that has no connection.
Yeah. losing the plot a little bit. It's just not well organized. It's not well argued. I'm thinking back to when TMZ's lawyer was arguing essentially, well, arguing similar, and it's just better organized.
And that's what I was like. Am I the only? Obviously, I'm not, because you made the point too. Like, he's all over the place.
Yeah.
There's a way to make the argument. He's not making it.
No, it's not well organized. He needs a outline, some case law and stuff, and some citations. Maybe you can get ChatGPT.
You're going to sanction him?
No, ChatGPT is not going to. Well, they might be able to formulate his argument because that's just speech. That's not the case law. But just maybe don't use that to find a case law that's
doesn't exist.
Yeah, let's not do that.
And contempt of court, you can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho Rules of Professional Conduct.
That pose right there, I have seen that. That was in direct response to the holding them in contempt. You can't. That was, you want to bet, counsel? Mm-hmm.
By commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I could go off and say whatever I want that they said.
I mean, hypothetically, technically, anyone
It's
could
the First Amendment.
have information that could come into the
I
case.
mean, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor. I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked up, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they'd never interviewed us. So they're throwing stuff in the air. It's not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Good.
Thank you.
Oh, I hate that. Oh God, that's amazing. That means
I am not going to ask any more questions. Thank you.
I don't know if that's Mr. Thompson or Mr. Rutherford.
Don't be mean. Can I have one comment, Your Honor?
Certainly. Thank you.
If I may.
I understand your argument. Yeah.
Yeah.
You don't think that's a good sign?
No.
You don't think we're on the path to victory?
No, I don't like that. That when a judge says that, I keep talking. I don't let him end with that. I understand your position, counsel.
Do you though?
There have been times when I have wanted to say that really bad. like just to be like, but judge, I don't think you do.
I don't think
but
so.
Do you, judge? Because I think that the back and forth suggests that you might not.
Yeah, I'm not gonna lie. I am
like Crest
disappointed that
toothpaste.
I am disappointed that we did not watch the attorney wheel out of there on his heels.
Oh, Santa is coming to make the argument.
Oh, yes. Prosecutor
Okay.
Santa.
Come on, Santa. Let's hear you.
Yes, you may.
Mr. Rudley is actually going to be arguing on motions themselves, but as attorneys, we have a duty of candor to the court.
Oh, shit.
Gray has made representations to the court that at best are misleading.
Oh, shit.
I need tea.
I need to correct them for the record.
Santa mad.
The media is here. I do not want the public
He's like,
away with
he is on the naughty list.
that improprieties
He is getting coal this year.
First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office as investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we provided more information is simply not true.
Wait a minute. Does that mean that you violated the gag order?
Good point.
Did he just say he violated the gag order?
Good point. I don't think the judge picked up on that.
Because I'd be picking up on that. That I picked because when he says that a third party, who the judge has just said repeatedly are not parties to the litigation, ask questions, and he's like, we have provided answers, and we did not provide answers when we thought it would impede the investigation. That's not what the gag order said. Gag order said nothing. So did the prosecution just acknowledge that they violated the gag order by providing information they should not have to third parties? And maybe that is why the third parties are giving that information to the public. But yes. If a lawyer represents someone who is not a party to the litigation, if it's a third party attorney, if some random dude's attorney calls me and says, hey, can you give me privileged information about a case that you're handling? There's not a special exception because they're an attorney.
Yeah.
So, okay.
Secondly, he claims that law enforcement has not interviewed his clients, and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. Just for the record, I want to make sure that's clear. Thank you, Your Honor.
It's called
If I can speak to that, Your Honor.
Whoa, that
You'll
was
be
all.
able to Come back in
Just
after
like-
you hear the other
Thank
arguments.
you.
Mr. Rutherford, go ahead.
He wants to get back up and talk right away.
Thank you, Your Honor.
Oh, Lord.
In State v. Spencer, the Idaho Supreme Court noted that it is
Wow, he
the
starts with a
duty
case
of the
citation,
prosecutor to
like a
ensure
real
the right
attorney.
to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims.
No. Buffering.
Buffer, buffer, you and me. Buffer, buffer, together we
on
heal. Friday night
television
frenzy.
talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada. That case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Graves repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonzalez families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly.
Two comments. One, you can see why the first attorney got up to make the argument first, like to basically point the things out, because that's the trial attorney. That's the person who has experience. This guy's reading from a mic or reading from a script.
Yeah.
Okay. We're going to make it through this. Two, just because the state files an affidavit saying we might use them as a witness, the state likes to play freaking games like that a lot. So I don't think that means anything. Why am I looking at the chat? What's going on in the chat? What's going on, guys? Owens? Yes, he looks like Owens.
Sounds like Owens, is what they're saying.
And looks like Owens. Like, is it Owens?
Can't tell by the back of his head.
I can't. Is it Owens? It's a fair argument.
I think Owens' voice was a little bit lower, though.
It's a fair argument,
just
Your
a little
Honor.
bit. Yeah.
Oh, okay.
Fully restrictive or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators.
No praying mantis.
The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so.
This is painful, guys. This is really painful. How long does he argue?
It is hard. It is hard.
Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. With that, I'll stand for questions.
Thank you, Mr. Redley. Do you think that would be helpful to just, and I asked Mr. Gray this the same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Oh, no.
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this.
He went back to the notes. Like he didn't know how to answer the question. He went back to the notes. This hurts my soul.
this case to address and preserve the right to a fair and impartial trial.
Can you go
That didn't
back?
answer.
You mentioned this about the standard particularly applied to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's
He did it again. This hurts.
no doubt that the court has authority, though it's in a footnote. It's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower
Don't
standard?
do it a third time.
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up.
Oh, God.
That's fine.
That the speech of lawyers may be regulated under a less
That's the right move.
less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that pretrial, that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order. Thank you.
Thank you for not giving any helpful answers. Like,
Judge, I think a lot has already been said, and obviously we wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case and therefore don't fall into 3.6, it would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation.
nope. Like, I 1000% I know why he's making the argument, but I 1000% disagree with him. No. It's not how that works. It's not some loose, you might have a right that's possibly affected somewhere down the road in this litigation, therefore the judge can bind you. Nope.
You fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just to fall within this and the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted.
Kurt, that is the White House phone number. That is the White House phone number, people.
How do you know that?
Because Kurt has it memorized. That's the White House switchboard. Do not call them asking for my name.
Call them asking for Wood Daddy Stacks.
Do not call the White House switchboard asking for my name. That is not my number. That is the White House. Oh.
Yeah, Rob, but how do you recognize that number?
Because Kurt said it once several weeks ago and I remembered it and I saw it and I knew that, yeah, no, it took a second, but that's the White House. That's the White House. Don't do that. If you don't want to end up on a list, somewhere, don't do that. We don't like lists. So just 8675309. Just dial that one. Jenny, you know, just not that number. Okay. Thank you, Kurt, for causing chaos.
Attack on the client. We also agree that at this point, the safety standard is for them just not be talking to the media and allow statements to be made here where we all get a chance to speak.
Uh-huh.
And the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody just trying to whip the media into a frenzy. And so in this case,
A Friday night frenzy?
Yeah, it's a Friday night frenzy. The media is in a Friday night frenzy watching a case that is like, oh, at least this attorney is like actually arguing and isn't reading off of a piece of paper.
Yeah. And actually, well, he hasn't had any questions asked of him yet, but yeah.
He's doing fine.
Yeah.
So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter a plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
Education?
All right,
Education.
Sorry.
it's your motion, so you can respond to what other counsel express.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have no contact as far as investigating and interviewing the victim's families. So somehow that I would prove that in some way, it's just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is, everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in court right now.
Because
I was gonna say, dude, like make the distinction right there on the spot because and the judge has the very appropriate Kevin McAllister dad smile. Solid.
Yep.
But he's in court making the argument. So maybe go a different path or make a distinction.
you're the one that brought me here because of the
You
non-dissemination.
brought yourself.
Yeah, well,
You're the one who filed the motion.
I did follow the motion because the non-dissemination order is unconstitutional.
Just try to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why
Because,
would you say that?
well, because
Okay. Oh no, he's losing it. He lost it. He's gone. He's off the rails. He has lost the argument. Oh shit. It started so promising. Oh, you were doing so well. Telling the judge this is the only time I'll be able to argue in front of you because you're preventing me.
I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once again,
Well, the Supreme Court has said they have standing to come into the court and address issues. So,
yeah, that's completely separate. They're not.
well, I know it's separate.
No, it's not.
So,
I also respect your position in representing the family's victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that was
implementing those victims into the trial in some way. Absolutely positive that wasn't your intention.
I agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them, but they were going to be potential witnesses in this case. And since then, every time we
was there another attorney representing them before?
We initiated that conversation. It hasn't been the prosecution initiating that conversation.
So you say since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this: in the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken this up.
I don't like the fact that he's saying I offered that up in some way.
Something and no follow-up whatsoever about anything. So,
oh no, you can't do that. You can't.
I don't like that. I don't like that he said, you know, I offered that up in some way, because it's like, it makes me think like, did he use smoke signals for it? And like, they didn't, you know, like he was like using it like very vague kind of language, and like they didn't understand, you know, like he wasn't clear, like, hey, you guys should interview my clients, or like,
and then
or
when he's
or
like,
please do, or, you know, like, I don't know, there's something about it.
But then he says they never asked, but then he immediately says, you know, there might be some random email, you know, somewhere, maybe an email like with no follow-up whatsoever, but maybe there's an email. That's,
It starts to feel a little bit slippery.
oh no, he lost this argument about 5 minutes ago. Like, he completely lost it. Like, there was a chance. He just he's done.
So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up, as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Becky. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between
That's
the state and Mr. Kohberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that was stipulated by all parties. I never stipulated to that. I emailed the judge.
You're not a party. You have completely lost any thread of argument that you had. You have gone off the rails. You are circular in your reasoning. Any chance that you have to bring this back on the rails is gone. I'm sorry.
Yeah.
Mm.
Yeah. It kind of feels like he went down the path of like just scooping up as many arguments as he could think of, rather than sticking to the ones that he thought were the strongest and the most likely to be listened to. Because then when you start adding in all that extra fluff, it just starts to, you get lost in the weeds. The judge starts focusing on other things, and like, it's, I don't know, so many aspects of this.
Well, and Griggsy, this is a great point. The Idaho State Constitution says the rights of the victims to communicate with the prosecution, to be heard, restitution, notification, fairness, refuse, interviews, reports, etc. Yes, those are rights, but are those rights that are being adjudicated in this particular litigation? I think there's a distinction, but the other thing about this is, you know what we haven't heard? That specific sentence.
Fair.
Yeah.
This argument, and yes, to say that the prosecution wants to shut you up, generally speaking, doesn't go well for you. What the hell is happening? This case is, oh God.
Hey, Ian.
I leave you
Ian's
guys
back.
alone for how long, and things go completely off
It's
the
I
rails.
not my
doxed Rob.
fault.
It was
It's
great.
not my fault. Shannon Gray had an argument right in front of him. It was right there. It was there. He had it for the taking. He's like, there's a great argument I can make. First Amendment, strong argument. And then
Yeah.
he just drop kicked it away. He's like, I'm gonna go crazy. Not crazy, really, but yeah.
Yeah.
Crazy for feeling so lonely.
There's 2 minutes and 40 seconds left. Okay. Here we go.
Party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties. As
So,
you correctly stated who the parties are.
so we
I
got,
agree, but you were suggesting that
Does that mean
it was entered to shut down the prosecutor's office.
why would they
That's what
try?
you just said.
I do think that part of the, that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
Okay, when you say they, you mean the prosecutor's
Yes,
office?
yes.
All right.
Do you want me to give you a final, or do you?
Go find it.
Okay,
You've already given your
We're not
final, my
parties.
friend.
God.
You've already given your
We're
final. It was
I have the
long ago.
right to repeat what my clients say to the media. I also have an independent right governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct, because I'm not litigating it or part of the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today. And
Very interesting argument. That's not how I want to walk away with that.
Yeah,
was
it's not-
was that
it's not
robot
super-
mode for everyone else?
it's not
No.
super encouraging.
Okay,
okay
then
for
I gotta run downstairs and see if I can get better internet connection here. I'll be back.
Okay.
Alrighty.
It's Canadian internet. What are you gonna do? It's only 77% as good.
One more minute.
I'll get back to work and try to get a decision out as soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
Yes, Your Honor. Have you considered that you're a petty tyrant?
Ms. Taylor?
Yeah, we thought you'd probably want to issue an order. Wait, I guess we're just wondering if in the meantime, the order as it is remains in place.
Yeah.
Thank you.
It remains in place until I address it. So, with that, we are adjourned. Thank you all.
Okay. Good.
Mm-hmm.
Yeah. It's going really well there for the attorney, I think.
Mm-hmm.
Really top level advocacy. Well organized.
You know,
Well thought
It's a-
through.
it sounds shallow to talk about what people are wearing, but sometimes that's an indication.
Mm-mm.
You think the shoes are basically the too long didn't watch?
It's
You
not
might be
the-
right.
It's not the basketball shoes that made Michael Jordan. It was Michael
Mm.
Jordan that made the shoes, the Air Jordan.
Mm.
But sometimes they're an indication of other things.
I don't know about that. I've seen public defenders walk in with like really crappy suits and they know the law better than anybody in the world. So I just that entire thing that started so well.
It didn't
And
really start that well. It wasn't well organized really from the beginning.
No, but the position I could see, and I could see that I was disagreeing with the judge on a lot, and there was an argument to be made. Like the doors were opened for the argument. Like, here's how you.
I mean, I
convince the
preferred
judge
monotone
wrong.
notes. That's how bad I thought it was. I mean, because at least monotone notes had thought it through, and his delivery sucked, but at least it. Yeah, I preferred monotone notes.
Uh-huh.
I preferred AI chatbot reading.
Kind of.
Yeah.
What the hell just happened?
With respect to what? You're gonna have to
I
narrow
don't-
that down, Rob.
There was not a lot of good litigation in that. I think the
Okay.
defense attorney was probably the best on the podium, and he didn't have to say too much because he knew that it was already in his. He already won.
Yeah, pretty much. Yeah.
What a disaster! Oh God. Oh, let's see.
Watching these trials is just continuous affirmation for me. That's why I like these trials. It's a continuing moral boost. I'm a good lawyer. And CLE is a continuous. I am the best goddamn legal presenter that's ever existed in the history of time. That's how I feel in watching every CLE. I'm the best that's ever been.
So
like I'm pretty damn good at explaining these things.
I just couldn't
Tell me
believe
I'm wrong.
any of that was happening. Oh, okay. All right. Let's we're gonna catch up on some super chats, and I'm gonna try and pick the ones that are applicable. I'm gonna save some of the others for later. Because we're gonna need to swoop to something more pleasant in a second.
We could swoop to some of the more controversial topics. I love you, Rob. I'm just here to cause problems.
Griggsy, I'm done with this lawyer. Contempt him 3 days. I don't. We know what Kevin's dad did for a living. He was a judge, apparently.
Yeah. Well, he probably was in private practice at the time that Kevin was little. That's why he had such a big house.
Gotcha. Debbie O, here you go. Can we put the shoe discussion to bed now? Cole Haan, $0 grand, laser wing, Oxford, ugly, yes, tennis shoe, no.
To be fair, I don't necessarily think that they're ugly shoes. Like if I saw somebody wearing those walking down the street, I would have zero problem. It's the context of them being in the courtroom that I just like the white rubber sole.
It's a taste
in a courtroom is just it just doesn't look professional to me.
It's odd. M169, thank you. The pose screams, you want to reassess your argument. Sure, you want to go there? That was a lot of vibe. Rihanna, thank you. Watched all EDB earlier, but I tend to agree with y'all more. So this time, great minds can differ. Yeah, we're going to disagree. We come from different backgrounds, different understandings, and different views of the law. That's fine. That's why attorneys exist. They disagree all the damn time. You do it respectfully. So yeah, I have no problem disagreeing with Emily, and no problem that she disagrees with me. And the game maker, I have no idea what's going on, but I have a question. Who would make a sexier Bond girl? Kurt, Rob, or me? Not Alita. She's gross.
It would be weird if Andy included me in that.
That would be very
more than
odd,
weird.
Considering he's your brother. But Andy has the blonde hair, therefore Andy's the Bond girl. So, Andy, you're the Bond girl. Thank you, Reardon. Thank you very much. I just Googled who is Wood Daddy Sachs, and EDB and Rob's names came up immediately, the #1 spot. That's scary. So if someone does call the White House, they Google the name Rob, will be on a list.
There you go. Yeah.
Okay. Torin, thank you very much. EDB's braid is done, ready to your braid, but need answers to 3 questions on Discord. 2 subs to 700. Diamond, drag, or end mill. Good night. The Alita didn't see this yet, so hang on, let me grab that.
Yay!
It is illuminated.
Rob is showing us all up in every possible
It now has
way.
lights. So light off, light on.
Nice. That's awesome.
You clap on, clap off.
It doesn't do that.
Okay.
But
what? Rob, I'm so disappointed.
Damn it. No, so that was not the diamond drag. That was actually an engraving bit. But yeah, Torin 3 on YouTube. Go check him out. Does some great stuff. So please check out the channel. Subscribe to him if you can. He is 2 subs away from 700 subscribers.
Woohoo! too.
It'd be awesome to see him get there. So
Could you
please go
make
check
one
it
that
out.
does like lava lamp and has bubbles inside that heat up and like rise up and fall down inside the acrylic?
Oh, that'd be
Yeah.
neat.
That'd be cool.
That'd be neat. Ryan Man YYC, how is Kurt singing can simultaneously fill my heart lifting joy and soul searing anguish? Because that's what music brings. Emotion.
It's art.
I
It
definitely
is.
make people feel things, that's for sure.
Kurt, in your $300 opinion, should jurors be shown on court TV?
No. That was happening today in the
No.
Scott Pitt.
No.
Yeah. 2 jurors at least were exposed today, and I think a juror was exposed yesterday by a long
No.
crime.
In the Peterson case?
Yeah. Yeah. We got some faces. We got some FaceTime by camera guy.
Ruh-roh.
Yeah.
What's gonna?
And,
I
the,
mean,
and at least one case.
did the judge notice?
He didn't mention it, at least in the court hearing that I heard. I didn't hear the full afternoon session, but he didn't bring it up at lunch, or at least the parties didn't bring it up. So I don't know if the judge noticed or not, but it's hard to believe they wouldn't have learned about it during lunch break. I don't know what happened in the afternoon session because I was covering the other breaking story of the day. But at least in one, he was trying to be like really, really cute about it. He was filming like basically, he's trying to film the floor of the jury box as the jurors walked in. So you could see the jurors basically from their like knees
Like
down.
legs down.
But the jurors are allowed to write in this courtroom. And where do they keep the notepads? Underneath their chairs. So one of the jurors came in and reached for his juror pad and so exposed his face to the camera.
I just, you're asking for trouble anyway. You know, like,
Yeah,
like,
no,
what,
no,
like
that's-
what if, for
that's-
example, what if one of the jurors like has one leg and one prosthetic? You know, like what if there's an identifiable?
No.
You can comment on their shoes if you like, because we were able to see those.
What the heck? Truffle Hound, hi Alita. So rarely get to see Alita live. So here's one for you. Do you know where the Magna Carta was signed? At the bottom.
I love
I was
it.
actually thinking about it. It's I know that it's about a half mile away from a piece of land that was dedicated to the United States for a JFK memorial.
Oh, interesting.
Of course, Kurt has like extra detailed like knowledge about this random thing that happens to come up.
I know. That's why Kurt's our friend. He has all the information.
Berkman Eggwood or something like that. They always have names like that.
Bova. Cheers to friends. Cheers to you.
Yay.
Rua. Big love. This is the rest of the replay crew this week. Big love to the replay crew. Always, if you are just tuning in, please make sure to like the stream. And if you have not yet subscribed, please do so. It's a great help to the channel. Let's see. I'm on replay crew, but wanted to say good evening to both Kurt and Rob. Thank you both for being here this evening. Hog. Hage. Hage. I am going to frick that up because that is Gaelic and Celtic, and I cannot pronounce that. It's like the Sláinte. I don't know how to do it. Kristen, has Alita met her bot yet? She has. And we got Kurt bot, Alita bot. Alita bot was around here somewhere.
Also, the Magna Carta was signed in 1215.
1215, really?
Pretty sure. Yeah.
Kristen, Kurt, is a bee fish or more bee?
Existential questions for sure. Ask the California Court of Appeals.
Mouse Girl, thank you for the super chat. Time, how do you feel about the Supreme Court? They are a panel of 9 Supreme Court justices that make decisions that have varying opinions and views on how the Constitution should be interpreted. They disagree a lot. They agree more often than you think.
Yeah. I think the Supreme Court
how do you feel about the Supreme Court? Not just details.
Well, which Supreme Court? The current one, the past ones, or all of them?
Yeah.
They've got a nice building.
Everything's been downhill since John Jay.
I tell you what, they get it right just about as often as they get it wrong. And that's not saying from one political side or the other. Doesn't matter. They get it wrong too. Mandalore Wise, I have a ThinkPad as a Linux server. Okay. They even have AI judges, says Time. I didn't know that. Actually, I saw an article about that. That's interesting. Oh, Leanne G. If you didn't read it yet already, can we have a palate cleanser, aka your ChatGPT bio? We can do that. We can do that. Give me 1 minute. Ian, can you help me with some super chats for a second?
Maybe. Let's see.
Maybe. There you go.
Can't hang out, but sending my love. I'm in Eureka Springs with the Duke, headed to Redneck Karaoke. So sending my love now. Have fun, F&F crew from Rosalind Duke. Awesome. I don't know what Redneck Karaoke means, but I suspect it means country.
How reductive of you. You should be ashamed.
And I see M. Beauvais saying swoop, swoop de oop, swoop de oop de oop. I think we could do that. Let me just find the swoop.
We're swooping.
I love it. Every time. It never gets old.
I have swoop powers. Stacy Walpole is saying, have either of you seen / read Judge Almeida's written judgment on Masterson's lawyers? It's interesting if you have yet to read it. I haven't checked that out yet because I've been in an airplane. Have you guys seen it?
I saw about it. I haven't actually read the actual order.
I will have to check that out because that one's been interesting.
Yeah.
Just between the three of us, who do you think is Rob's favorite? You know he has a favorite.
Ian,
Yeah,
obviously.
I just suspect it's one
definitely
of his unicorns. That's
it's the guy that he has like matching, not matching ties, but like swaps ties with.
I've got the tie. Do you see the tie behind?
Yeah.
So I'm here at a conference, but I brought the tie. So I was like, I also love this chat comment. Kurt woke up and chose violence today.
It's most days.
Okay.
Violence is fun.
So,
Rob, we were talking about how Ian is your favorite.
Rob is like, I'm going to take a long drink of something.
I know. I was like,
there are no favorites.
it's
I have
okay.
no favorites.
We all know. It's fine.
I have
Ian
no
can
favorites.
be your favorite friend.
No, I have no favorites. Ian just keeps me on my damn toes.
Rob, do you want me to take off my clothes again?
No, God, no, please, no. Don't do that. We don't need to do that. So the transition that's funny. We're not going to talk about the ChatGPT lawyer stuff because Ian's going to talk about that Monday, and that seems like an appropriate Monday conversation. I know Emily talked about it. We're going to see if the judge makes a ruling on Monday. The judge reserved judgment.
I hope so.
I hope he uses ChatGPT to write the decision. That'd be good.
Oh,
that would be hilarious. Oh my God, that would be so funny. Or like, here is the decision ChatGPT wrote.
No.
And then here it is after I actually went over it and corrected it.
Yeah, that'd be good.
Because
yeah, I like that.
You know, it would be improper to just give you the ChatGPT version. Yeah, and he should put it in like with the prompt. So it's like write a decision absolutely trashing a few terrible attorneys for
there's potential
negligently using ChatGPT.
Potential. This is terrible potential.
If you need help, Judge, I'll help you on this one. Do it for free. It'll be great.
Oh no, this is gonna be terrible. But I was watching Emily talk about this, where the attorney used ChatGPT, which created 6 cases that did not exist.
Yeah.
And then attached the 6 cases to an affidavit saying they do exist because ChatGPT said, "Trust me, bro." And I was following that. Yeah. And
that is the wildest. That is the wildest aspect of this. Where, I mean, I can get how a lawyer would screw it up and just be like, "I use ChatGPT," but when the other side is like, "Your cases don't exist," I'm going. That is the time to, that's like somebody going, I'm pretty sure you are in a minefield right now. And that's the time to maybe stop dancing. So
like ChatGPT, you love me, right? You wouldn't lie to me, would you? You wouldn't lie to me and create cases just to win my approval. Would you do that? That seems like something you wouldn't do.
Yeah.
And ChatGPT's like, no, I would never deceive you. You know what?
Yeah.
Are we saying that ChatGPT is an abusive significant other?
It is. Have you seen some of the stuff that comes back on the prompts?
Fair enough.
Did you guys
is Agatha from WandaVision?
Did you guys see the one with Eliza? That one is interesting. Eliza's going to get sued. So this guy was depressed about climate change. And he started talking to this chatbot, like an AI chatbot.
No.
This is a modern Eliza. It's not the old, like the one from the 80s and whatever. So it's an AI chatbot. And this chatbot eventually starts feeds him the notion that the solution to his climate change fears is that he could self-delete. And says, when this happens, we can be together forever, because there's indications as well that he was like losing his grip on reality. And so the allegation is, and like there's a bunch of very specific details in the article I was looking at in terms of the allegations about what this thing was doing. And so the article I read ends in, I want to say hilarious, but it's too dark to really be hilarious. So it ends with the reporter saying, we went on and we asked it about self-deleting, and it told us not to do it. And then it detailed a bunch of methods and how to do those.
Gaslit him.
Like, and I was like, oh, wow, that is bad. Like when you're talking about the lawsuit on that.
So what are the damages that are being alleged here? Is this his family that's suing?
This is his wife.
Oh no.
Yeah, I would say loss of consortium. You have a claim there.
Loss of income.
Sure.
If he was making any money.
Yeah. No, I what I was asking for was, did he end up taking up the suggestion?
Oh no.
Yeah. So
how many zeros would you like at the end of that check, says whoever created that bot?
That is kind of the thing. And I mean, I have been the lawyer before on the conversation where you're just like, here is the deal. You're going to write a check and it's going to be a big check, but you don't want this to be the top of the news cycle for however long. So how about we write a check right now? And everybody can be happy. And, because if I was that AI company right now, I would be going, A, we're taking everything offline. B, we are writing some major, like a big check. Ian? And C, it is going to have the most detailed non-disclosure agreements in it ever.
We are going to palate cleanser mode.
Yes.
He's like, this is the palate cleanser.
There we go.
Good move. So
I need more swoops in my life.
In EDB's chat, I asked the question as we were talking about ChatGPT. And I said, I wonder what would happen if someone wrote a question and said, could you give a biography for Wood Daddy? Well, one of EDB's mods thought it would be funny. And she actually wrote the question to ChatGPT. And what we have is ChatGPT's answer.
I love it.
Can you please write me a biography for a dating website about an eligible bachelor, Wood Daddy, but use legal language?
Oh, God.
Yep. Is that good? Biography of Wood Daddy. Disclaimer. The following biography is intended for entertainment purposes only and does not constitute a legally binding document. Any resemblance to real persons is purely coincidental.
It's already leaning hard on the legal language.
We're going there. Wood Daddy, a charismatic and accomplished individual, is pleased to present this carefully crafted biography for the purpose of acquainting potential suitors with his background, qualities, and aspirations. Please note that this document does not establish any contractual obligations or rights.
Good start.
Personal overview. Wood Daddy, a pseudonym, is a single male adult of legal age, and his true identity is withheld for privacy purposes. He possesses a strong sense of individuality and embraces.
This is starting to sound like a Grindr profile rather than a Tinder profile.
It keeps going. Wood Daddy's interests, preferences, and lifestyles are outlined below for informational purposes only and do not represent binding commitments. Ergo, we do not commit to preferences, interests, or lifestyles. I don't. This is weird. Background. Wood Daddy's personal history and background are an amalgamation of experiences, skills, and perspectives. While he values his privacy, he understands the importance of providing some context to foster a meaningful connection. Information provided herein is subject to his discretion and may be subject to change without notice. So, experience, skills, and perspectives subject to change without notice. Personality traits. Wood Daddy is a kind-hearted, compassionate, and empathetic individual dedicated to treating others with respect and dignity. He values open communication, honesty, and integrity in all aspects of his life. He personally may exhibit a range of characteristics, including but not limited to charm, wit, and a strong sense of humor. Please note that personal compatibility is subjective and dependent on individual preferences.
I mean, quite literally, yes.
Can we talk about how ChatGPT has created a disclaimer at the end of every fucking paragraph? Yes. Every paragraph, it's like, this might be complete bullshit.
Good ChatGPT.
Good. Interests and hobbies. Wood Daddy is an avid enthusiast of various activities and hobbies. These interests may include outdoor pursuits such as hiking, camping, and exploring nature's wonders.
Are you an outdoor kind of guy?
I do enjoy the outdoors very much so.
Okay.
Furthermore, he appreciates cultural experiences, including but not limited to attending art exhibitions, theatrical performances, and engaging in stimulating conversations about literature and music. Oh, sweet. Professional background. While the specifics of Wood Daddy's professional life remain confidential.
Whoa, why is that?
Spy? It can be noted that he is a driven, motivated individual with a strong work ethic. His occupation achievements may encompass a broad range of industries, disciplines, and accomplishments. Potential suitors are encouraged.
I mean, it's really one industry, I think.
Potential suitors are encouraged to inquire further should mutual interest and compatibility arise. Expectations and aspirations. Wood Daddy acknowledges the importance of establishing expectations and aspirations in any potential relationship. However, it is essential to recognize that the nature of such expectations may vary and evolve over time. It is recommended that interested parties engage in open and honest communication to foster a mutually satisfying connection. What the fuck?
Not bad.
Legal notice. Oh, God. The content provided in this biography is not legally binding and is solely intended for informational purposes. Wood Daddy reserves the right to modify or amend any aspect of this biography without notice. Nice. I feel like that's not what biographies are.
Depends on, I suppose, what kind of person you are.
Potential suitors are encouraged to exercise due diligence and discretion when engaging in any subsequent interactions or relationships. My God, there's one more. I think there's one more.
It's like you're later, like you have this conversation where she's like, you're not the man I thought you were, and you're like, well, it was in the disclaimer, okay?
Did you not read the disclaimer that this was subject to change at moment's notice without notice?
Disclaimer's key.
Please note that the above biography is fictional and should be adapted.
Can I get whiting vowels written in legal language?
Oh, I don't know. But this is an example. Like if you guys want to mess with ChatGPT, this is a pretty good troll. It is always important to exercise caution and discretion when interacting with individuals on dating websites and prioritize personal safety. See, good for you, ChatGPT, and warning people about the fine print.
Or maybe it's just warning people about you specifically. That's concerning.
No, this is a hypothetical. Did you not read the very beginning of this?
Hypothetical.
You didn't read the beginning. The following biographies were intended for entertainment purposes and only it does not constitute legally binding. Any resemblance to real persons is purely coincidental.
Given the effect that this has had on the chat, I feel like I have to play a video, and I don't know if Alita has seen it at this point.
I swear to you, Ian, depending on which version of this video, I might punch you from cross international borders.
There's only the one that you've still got uploaded.
Do it. Do it. Do it.
What was that?
I am so mad at you.
You're the one who hasn't removed that from your list of friends.
I thought the only one that was left was the toilet flushing sound. Damn it. Oh.
You're not digging it, Alita?
No.
The level of
this sound,
discomfort.
especially.
Oh no. Oh.
Play it again.
Nope. I'm removing now. Delete. Hang on. Stop. Nope. Delete video. There it is. It's gone.
There we go.
I can bring it back though. I can bring it back.
Nope.
You want
We are
that?
not doing that. We are not playing that
You
game.
want that?
Oh no. No. Ian, I did not see that coming. I should never, ever, ever. When you travel, damn it, you crazy Canadian son of a bitch.
I mean, the thing is I don't have a local copy of that video, so the only way I had access to it was it's in your brand listing.
Oh, that's
For
so
your brand
uncomfortable.
identity, yeah.
Okay, so that was a palate cleanser.
Palette cleansed.
Palate is cleansed.
I mean, I don't feel very clean.
Right?
It doesn't feel clean
That is
here.
such a fair statement too. Oh my god, this is so bad. It is so bad. I need the lion head. The lion head needs to come on. I need to hide under the lion. Alita hasn't seen the lion head yet. Here's a lion head. This is why Fridays are what they are, because we all need to fucking laugh from time to time.
Yeah.
I have a lion mane. It does the hair shaggy thing too. I wonder if I put a hat on top of it. That doesn't work.
It looks like the bear's or the lion's wearing a hat.
That also doesn't work.
So it's some sort of wood lion hat stack, is what you're saying.
Apparently. Oh no. So, well, now that we have explored ChatGPT and what ChatGPT can do for you or anybody else in the world, okay. I can't play. So I see people saying play Uptown Funk. I can't play that. That is actually
They
Bruno
will
Mars.
strike.
I will encourage people though to please go search Lawyers and Dragons Uptown Funk.
Oh, it's so good.
It's so good. Yeah.
Yeah, it's a lot of fun. So, what was on the docket? I was too panicked to realize where we are right now. What did I have? I had stories. I had them queued up.
Do you have them like notes somewhere? Like maybe in a Word document or
FTX and Sam Bankman-Fried.
Oh, is he up to more?
What's the latest?
Honestly, so let's do a swoopy swoop. New swoop. No, Kurt.
At least it doesn't have the audio. Okay.
But you can hear the audio in your head.
No, you can't. You shouldn't. That should be ignored. So
I'm here to help Rob. I'm helping.
Yeah, you're helping just like your character helped in Lawyers and Dragons. You decided to spit acid on an
are
entire
they within
time
30 feet?
nowhere.
Can I spit acid on them? Yeah.
Yeah.
Oh God. Okay. So, and the chat is now dead. The chat is now dead.
Yeah.
Kurt the Bringer of Chaos. I love it. Yeah, this is kind of this is the chat is now deceased. So so there were developments in Sam Bankman-Fried. Sam Bankman-Fried, just pulling up what I had to see. So Bankruptcy Court, and I'm going to do like a quick recap on this. So you guys remember that the Bankruptcy Court has been kind of fighting over jurisdiction on whether it should be argued in the Bahamas or in the U.S. And the judge finally decided U.S. We're not giving jurisdiction to Bahamas. I'm not going to follow them. U.S. it is. The judge also said that the customer list can be redacted. So the customer and creditors, because there was extensive expert testimony on this, like how the dark web can find all of these people. And the customer list is pretty extensive. There are billions being held, millions being held, etc. So the judge said, no, that can be redacted. However, the list of, where was it? The redacted statement. Pull this up and share the screen. Come on. You can do this. No, a drawing error has occurred in the fucking PDF file. Since when? Oh, there it is. Okay, good. Present. We know how to do the things. Window. All right. So this is essentially the list of individuals who are the creditors or the committee. These are the individuals that have the right to vote on the plan, to submit the plan. These are the highest interested parties in FTX. And the judge said that these people, because they're they might be engaging in self-dealing if they were to buy an asset in an exchange at the end of the day, they have to disclose their names. Look at the amount that each of these individuals owns of FTX. So all these redacted names are being unredacted. The addresses are going to remain redacted. So 150,000.
You can't go visit them?
1.1 million, 11 million, 85 million, 890,000, 5.8 million, 21 million.
Are some of these governments?
No, these are people. They're individuals. 420,000, 4.5 million, 5.5 million, 560, 5.7 million, 10.39 million, 500.
Uncivil Law would like to announce the launch of Uncivil Coin.
32 million,
Uncivil
12
Coin
million,
is best coin.
804, 1.
Also known as rug pull coin.
So these individuals were arguing very, very, very hard to prevent, especially.
Is that 1.5 billion?
This individual.
Holy shit, dude. 1.5 billion. Well, yeah, that'll get my attention.
So these people were arguing very hard to keep their names off of any of these proceedings.
Yeah, no kidding. I would like to know who's got 1.5 billion to throw into this.
Yeah.
$100 million, $27 million, $79 million. So those are the.
I'm just gonna say I'm
me,
real
Uncle.
close to that.
It's me.
I'm only like a
1.5
billion away from that.
So the judge basically said, "Hey, I'm going to give you counsel for the committee, because this is it's the committee of the largest unsecured creditors that get to vote on the plan, propose the plan. They are the ones that the court views as having the best voice for the rest of the creditors, right? They're going to want to maximize their return. And the judge said, nope, they got to disclose their names. But I'm going to give you a week or two to go back to the committee members and say, do you really want to be on the committee? And that's going to pose a very difficult question because a lot of these people have a lot of money at stake. And it's a question of, do I want my name out there publicly, or do I just withdraw from being a committee member? So within about a week, we're going to see who these people are.
Or they're going to drop out.
Or they're going to drop out. And I am very curious to see what names on this list change.
Yeah, that'll be interesting.
Well, I can't let people know I have this kind of money, so I'm gonna drop out.
But you know, I think who the 1.5 billion was. Because there was an adversary proceeding that was filed pro se seeking 1.5 billion in a claim. And
1.5 billion, and you're going to represent yourself?
I mean, clearly an individual that, you know, is filing an adversary proceeding for 1.5 billion pro se is obviously this intellectual creditor that's part of the committee. I'm being sarcastic. So this was filed in the bankruptcy case May 31st. And basically Mr. Leslie Stewart, a party in interest, is
maybe that's Elon Musk.
1.5 billion. Oh shit, he might be. 1.5 billion damages.
That was my thought too, but I'm like, no, that's not.
And he's going to self-rep it.
So this is a pro se complaint that was filed in the bankruptcy case, and it goes about as well as any pro se complaint you could think of would go. At all material times, the plaintiff was a party in interest from the Commonwealth of Bahamas before FTX Bankruptcy Court within the state of Delaware, U.S. Okay. On the 3rd of January, plaintiff's preliminary witness statement was filed in docket number 357 in objection to the Chapter 15 motion for COMI filed by the Joint Provisional Liquidators. Please don't allow reorganization in the U.S. Plaintiff mailed a second statement to the FTX Bankruptcy Court within the state of Delaware, USA, which indicated inter alia. I never pronounced that right.
Inter alia.
That the U.S. Embassy in Nassau, Bahamas would not grant him a visa to travel to the U.S. to physically participate in the bankruptcy court proceedings.
Wait a second. He has $1.5 billion and he can't manage to get a visa to the U.S.? What's that all about?
He has a 1.5
billion. He's also representing himself here.
I kind of feel like for 1.5 billion, you could just like buy a state. And
we're going to get there.
But it's like, I'm a citizen now because I own Texas.
No, Wyoming.
Texas, you couldn't buy for 1.5 billion.
Okay, maybe like American Samoa,
Vermont, maybe. But the clerk of the bankruptcy court this time requested a filing fee. The audacity! And informed the plaintiff that his second witness statement was not in the proper form and refused to file the plaintiff's second witness statement in violation of Rule 5005A of the rules of the bankruptcy court, which dictates.
This is why you hire a lawyer, peeps.
The clerk shall not refuse to accept for filing any petition or other paper presented for the purpose of filing solely because it's not presented in proper form as required by these rules. Oh, it's a lawyer. It's a lawyer. The plaintiff is a party in interest and had a statutory right to be heard under U.S. Bankruptcy Code Section 1109B in all bold, which dictates a party in interest. Emphasis added, includes the debtor, the trustee, a creditors committee, an equity security holders committee, a creditor, an equity security holder, or any indentured trustee may raise and appear and be heard on any issue in case under this chapter.
Although they don't say emphasis added here. That was your own addition.
I know, but it
Which
was
you should have said it.
They should have said it.
Should have said it. This is why you don't do pro se.
It's true. The plaintiff, as a party in interest, already recognized by the FTX Bankruptcy Court in docket number 357. Look, just because you file something saying I'm a party in interest doesn't mean the court recognized you as a party in interest.
But you accepted my filing.
You accepted my filing. You date stamped it.
Oh,
did they? Did he? That's funny.
The law society where I am actually had to change the rules of ethics as to what you could and couldn't notarize, because the old thing that the SOV sits were doing is they'd go to a lawyer and they'd be like, please notarize this. And the lawyer would be like, okay, it's a true copy of your other document. And then they would be like, this is a legal document. So it's now unethical in Alberta to notarize Sovsit anything for any reason, basically. So yeah, just because this is the kind of trick people like, or the kind of thing people think matters, and it doesn't.
Well, because I mean, the thing you have to explain to people is like when you have a document and you take it to a notary and they do their thing. They're not notarizing the document, at least in the United States. In other countries, you know, notary is a different function, but it's like they're notarizing your signature, basically saying, yes, this is the person who signed this paper. I don't know anything about any of the other words on here. It's this signature is real.
To emphasize Alita's point, when I was studying for the Texas bar, it actually came up because apparently in Mexico, the title of notary is kind of
notario
or attorney-like adjacent. They actually have a fair amount of power to do things and sort of like land deals. I didn't quite understand exactly what it is because I'm not a lawyer in Mexico. I didn't understand, but they had to create a special rule of ethics in Texas because of this issue, because Texas being a bordering state, there were people who are really like, oh, I'm a notary public, which is true, but it doesn't mean the same thing here that it means in Mexico. And there's unauthorized practice law issues.
Very common method of like fraud.
Yeah. Like Australia, France, I think both have like similar to Mexico, I think.
Mm-hmm.
Correct me if I'm wrong, chat. I'm sure there's
I think notaries can do a lot in other jurisdictions. Yeah.
Yeah.
So, but let's hammer down to Mr. Leslie Stewart real quick because he's a party in interest because he filed something in the court. And now he's become a victim of tampering as a victim and a witness by the U.S. Embassy in Nassau for denying him a visa or permission to travel to the U.S. for physically access to the FTX Bankruptcy Court in violation of 18 U.S. Code 1512, 18 being the criminal.
Oh, wow. Denying me a visa is tampering with a witness. Well, first of all, even if it is, it's the U.S. government doing it. So go to hell.
Yep.
Yeah.
Yep. And then highlights by any person or judge of the United States
for
possible commission for hindering or all of this other stuff. He cites different rules and he gets to intervene and he wants all these things.
What country is this person from?
The Bahamas. We're going to get there. Trust me.
Okay.
Of course it was going to be the Bahamas.
It's always the Bahamas, but it's basically
but
saying,
like,
you know,
I feel like they're saying the Bahamas and that they're really from somewhere else.
Revert the Bahamas to British rule. It's the only way.
Well, here we go.
There might be some Bahamians that disagree with you.
Well,
revert Canada to American rule. It's the only way.
I mean, I am getting
going.
We could use the Second Amendment here.
Moving forward beyond the subversion of different constitutions and rules and all this other stuff. The plaintiff informed the trustee on March 30th of 2023 that the attorneys informed the trustee, the attorneys for the joint provisional liquidators, and the attorneys for the debtor that their participation in the signing of the fraudulent court order would prevent the debtor's discharge from bankruptcy, consistent with the ruling in the case of Bartenwerfer versus Buckley. They're citing Buckley. Wherein the U.S. Supreme Court said that Section 523 of the Bankruptcy Code renders any debt procured through fraud non-dischargeable, even if the debtor was not personally involved in or had no knowledge of the fraud. So now these orders are fraudulent. Everything is fraud.
I'm not quite sure that's exactly what they said in that case, and that because in that particular case, it was a wife of a husband, so she got liability because essentially she was effectively a partner, and because even though she didn't have specific knowledge as a partner, she acquired liability through the nature of the partnership.
And they basically said, you actually, yeah.
So I'm not quite sure that's quite what the Supreme Court said, although I could double check.
You're right. So the plaintiff's claims a declaration that the plaintiff's first amended motion for a court order submitted on the 6th of February 2023 is a valid motion before the FTX Bankruptcy Court, notwithstanding the failure of the clerk of the FTX Bankruptcy Court to file their amended motion in violation of Rule 5005. Okay.
Random semicolon.
Failure of the
thereafter
clerk, or maybe more like refusal of the clerk because you did something wrong. That's more likely.
A declaration of the plaintiff is a party in the interest recognized by the Bankruptcy Court in docket number 357. We're getting there. And therefore should be allowed to intervene.
And by the way, on the part about the failure of the clerk, it's generally not the best strategy to get, to get the judge to your side to talk about the failures of their clerk because they're pretty tight.
Well, they kind of double down. Look at paragraph 26.
Be mad at you.
Look at paragraph 26. A declaration that the clerk of the Bankruptcy Court obstructed justice against the plaintiff when she refused to file the plaintiff's additional submissions to the Bankruptcy Court for filing in violation of 18 USC 1509.
Also, there's an erroneous semicolon there. There's a lot of issues here. It may seem ticky tacky, but these things add up. Sometimes they're signs.
Yep. So we're also going to 18 U.S. Code 1519 and 18 U.S. Code 1512. So we're just going to just say all the criminal statutes. That's what we're just going to say. These are all violations. My rights were trampled on. Court, you have no jurisdiction over me because I am not subject to your jurisdiction, but also—
Wait a second. If the court has no jurisdiction over you, then they literally can't accept your filings.
I know. Please grant me jurisdiction. It makes no sense. A declaration of the fraudulent court
order. That's not how that works. The court doesn't grant you jurisdiction. What?
I know. A declaration of the fraudulent court order drafted by the U.S. attorneys for the joint provisional liquidators of the Commonwealth of Bahamas is in collusion with concerned together with the FTX debtor in bankruptcy, was drafted with the intent to impede, obstruct, or influence the investigation or proper administration of the bankruptcy proceedings within the jurisdiction of FTX Bankruptcy Court in violation of 18 U.S.C. 1519. So the government and their attorneys are also in violation of federal law.
They're all colluding to try to prevent this FTX bankruptcy from going smoothly.
All the fraudery, every bit of fraudery. But I wanted to get to his claim. Here we go. $1.5 billion in damages to the plaintiff for all the statutory and civil violations committed against the plaintiff by the debtor in bankruptcy.
Okay. So they added up some fancy fictional money and just said, this is what I'm owed, as opposed to being like, I actually invested this much money.
I think it was a pretty number that seemed really big. And then they want that declared non-dischargeable. So they want all those things. And then they want punitive damages against the debtor in bankruptcy. And then they want pain and suffering and emotional distress. They want all those things.
From the clerk.
Well, they want it from everybody. And they also, so docket number 357, which seems to be the origination of this guy's claim. So let's find out what that one was. What was docket number 357? That was this. The preliminary witness statement of Mr. Leslie Stewart to FTX Bankruptcy Court in Delaware. After my email to Attorney Andrew Vera, trustee for the creditors, the Bahamian government realized that their application for the FTX bankruptcy proceedings to be moved to Nassau was in jeopardy, and that members of the Bahamian government could be indicted by the FBI for using their Supreme Court to take money of the FTX exchange for Sam Bankman-Fried. That's not how you hyphenate that name.
Oh, no. So many problems.
And for using their Supreme Court judge to muzzle my case against the Bahamian government for corruption. So the Bahamian government caved to the indictment pressure put on them by the FBI to arrest Sam Bankman-Fried. The corrupt Bahamian government has now thrown Sam Bankman-Fried into the wolves, and my hope for and prayer is that he is kept safe while being kept in that very dangerous Fox Hill prison.
Fun
in
fact,
the attachment
his
provided,
name is not SBF, it's SBMF.
It's SBMF. In the attachment provided, you will see that my case in the caption is directly tied to the FTX proceedings, wherein my case establishes the evidence to prove that the Bahamas government is not a competent jurisdiction and should not be granted the center of main interest, COMI, designation to hold the FTX bankruptcy proceedings within the Commonwealth of Bahamas. But then you complain about the U.S. Okay, we're going on. Without any request by me, my Bahamian court case in the caption has now been transferred from one Bahamian Supreme Court judge to another Bahamian Supreme Court judge, who's a partner in the law firm of Mr. Brian Sims, who's representing the interests of Sam Bankman-Fried and the Bahamian government.
I hate to ask the obviously stupid question, but what does a U.S. judge? No. What does a U.S. judge have anything to do
Nothing
with whether one Bohemian court transfers to another Bohemian court?
Bohemian.
Nothing.
Bahamian?
Court.
Bahamian? How would you pronounce it? What is
Bahamian.
it? Bahamian? Is it Bahamian?
Yeah. Bahamian. But now we're concerned.
But now I want to pronounce it Bohemian.
Bohemian.
And I'm like envisioning all of these like rugs
can use it
in the room.
synonymously.
I thought it was Bohemian, and I thought it was named after Bahamas. Is it not? Did I get my etymology wrong? Have I made
etymology
it
is wrong on that one?
Have I made it stupid? Okay, I'm a stupid. I'm sorry.
No, you're not a stupid.
You're not a stupid. Do we have Bahamian SOV-sit crypto investors now? Apparently.
Well, I haven't heard anything about them actually being an investor.
Well, here we go, because now we start to get into the meat of it. My fate and the fate of the 7 people I represent are now hanging in the balance. Due to this Bahamian judge's intent to defraud the FTX Bankruptcy Court in Delaware by delaying of the hearing of my court case of corruption against the Bahamian government in order to assist the application of Mr. Brian Sims for the FTX Bankruptcy COMI designation for the Bahamas before the FTX Bankruptcy Court in Delaware, and a big payday for the judge in the process. Okay. My clients and I have a legal right to intervene in these bankruptcy proceedings.
Wait, this guy's pro se. What's happening here?
I don't know. So, but now we have Maxine Waters entering the chat.
Oh.
On the 22nd of November 2022, shortly after the FTX exchange collapsed, I sent an email to chairwoman Mrs. Maxine Waters to inform her that I have evidence in my case in the caption to show that the Bahamas government is a corrupt government and that their Chapter 15 application to the Bankruptcy Court in the U.S. to have the FTX bankruptcy proceedings transferred to the Bahamas should be denied.
What?
So, okay, Maxine Waters.
Why? Okay, why does he think that she can do anything?
Well, he then finds out that Mr. Bankman-Fried donated to Mrs. Maxine Waters, which might suggest why his information, which was so valuable, was ignored.
On this particular occasion, I'm not sure that's the reason.
I wouldn't be inclined to agree with you, Kurt. And now we've got Bill Clinton, Tony Blair entering the chat. This is what you would think it would be. You may want to consider putting me. It gets worse. You may want to consider. As I explained to Mrs. Maxine Waters, I am in fear for my life here in the Bahamas because of the evidence I have in my possession of the enormous amount of money involved, together with the culpability of the Bahamian government officials here in the Bahamas, where murder for hire is cheap as $500, which can be confirmed.
I bet you can do it for less.
Embassy in Nassau.
I bet you can do it for less.
I think that you're also probably right here.
Because I have made a claim for $1.5 billion.
Oh my God! He says Rico at the end. He says Rico. No, please, no.
We have to read it. You may want to consider putting me in witness protection within the United States immediately before I disappear, along with my court case and all the evidence I have of a corrupt Bahamian government, which may be allowed to hold the FTX bankruptcy proceeding within the Commonwealth of Bahamas, wherein all creditors will have to contend with a dysfunctional and corrupt judicial system. Please contact me for the evidence of a corrupt Bahamian government, which will provide the FBI with probable cause to prosecute FTX Digital Markets and all of its accomplices under the RICO criminal statute.
Help.
Please find the attachment I sent to Ms. Maxine Waters. Haven't heard back. Gonna be deleted. Oh, they redacted. They kicked that part out. So, do we think he's on the creditors committee? He's clearly that $1.5 billion figure there, right?
I mean, he's as sane as any of the other of them, so sure, why not?
So when I was interning with the Attorney General's office during law school, I was working in the correctional law section, civil law. So it was all people that were incarcerated in California and were suing the state of California for whatever reason. There were some legitimate reasons. There were many not legitimate reasons. And this, like what we just read, reminds me a lot of like the kind of stuff that they deal with in that office. That's just like crazy person talking crazy talk, and like some lawyer has to respond. Some lawyer sometimes has to actually literally cut and then rearrange the things that were written by some person in prison.
And the response just be
and
no?
then put it back together.
Well,
the response just be no?
But you know what's
Sincerely,
funny
yours,
about
Attorney
that?
General?
You know what's funny about that? I just tried to type Bankman-Fried and I typed bank-man. Son of a bitch.
Like, was
No,
that
but
just
you know
because he
what's-
was trying to emphasize the bank and Bankman?
It was fantastic. But what's funny about that is the U.S. Supreme Court receives a very, very large number of handwritten petitions for certiorari.
Really? Okay.
Most famously, I think Gideon versus Wainwright.
Sure was.
Handwritten.
Yeah.
And that
successful petition. He won.
Exactly. Winning. So it's still important that people read them, which is why they're part of the public record, because every now and then there are these little nuggets of.
There's been like one Gideon versus Wainwright, though. So it's not very often.
It, but you still
and
read
a lot
it.
of other very much non-that.
Yeah.
It's true. You still read it though.
Oh yeah, of course. I mean, someone has to. These are, you know, they're petitions to the government in some form or another.
All right. So, and then the last thing on the SBF update were these three statements / motions. Let me open them up. And that's going to bring us to the end of the SBF stuff.
Yeah.
And I think that's going to be the end of the docket for tonight.
Oh,
I know. I want to actually get some sleep.
okay.
So Sam Bankman-Fried is upset that the government isn't turning over documents.
I mean, it's a standard complaint.
It
Every
is.
lawyer is going to bitch about discovery.
They're a little bit late, though. So motion to compel, filed by Bankman-Fried. Let's get to the meat of the argument. Mr. Bankman-Fried respectfully submits this memorandum. Make them turn over all the stuff or let me get it from Fenwick and West. So without going through all the facts, Fenwick and West were the attorneys that were originally hired by FTX to be counsel for FTX when they were creating all their entities in the US. So there's an interesting argument that Fenwick is hiding behind, and I don't think the US has come out and addressed, is Fenwick is saying we can't give you communications between us and FTX because it's privileged. Bankman-Fried was an executive at the time, so there's an argument that he would be entitled to it because he was a participant or was in that capacity at that time.
I don't think so.
Fenwick and West is saying we don't have to give this to you. But there's also the part where the government is relying on it in some fashion. And John Ray, in the bankruptcy case, has already turned it over to the government. So,
well, if the government has it, he should be able to get it from the government.
And that's what it is. So John Ray, they're using John Ray in the bankruptcy case, who has said, I've cooperated fully. I've turned everything over to the government. And they're using that statement and they're saying, hey, we know that John Ray has all this communication, but you haven't turned it over yet. And you're going to use it. And the government's like, the government has been silent. They have not communicated about it. They haven't exchanged information. They haven't done anything. They've said, we're going to give the supplementation, but they haven't done it.
Okay.
And they're several months behind on their disclosures.
Yes, they filed a motion to compel. I like
That's
it.
what they did. They filed the
Yeah,
motion to compel. So they're saying, give us this information. Please give it to us.
Great.
What I found curious about this was Everdale writes this declaration and says, and this is the John Ray stuff. So this is where Ray says, I'm cooperating. I give everything over the government. But then here's the update. Government's now missed several discovery deadlines that it offered to the court by more than a month. At the conference on March 10th, the government stated it would produce by the end of March the contents of 5 remaining electronic devices. So this is Ellison's laptop and iPhone, Wang's laptop, contents of 2 laptops provided by FTX software developers. So those are big ticket items. And they said they were going to give them by March 10th. So they said we're going to give them over. Then on the 30th, they revised the promise and said, we're still working on it. And we're going to give it to you by the end of April.
And still not so much.
It's still not so much.
No, here we are in June.
Yep.
I mean, at this point, I'd be filing a motion to compel. You better believe it.
This case is set for trial in October.
Not a chance. No way.
So they missed the production in April. They didn't receive the search warrant documents until the most recent production in May. So that's a month late. They're still waiting for the government to produce the remainder of the laptop, the remainder of the search warrant documents, etc., and a bunch of these remaining documents. Well, what I found curious about this was I get that we do a lot of this bullshit in litigation. Why is this not pulling up? I need you to pull up, please. And I'll just show this on a recap because I'm having trouble sharing the screen. But what I was curious about was this. So this is Everdale's motion, or this is Everdale's motion here saying, hey, we haven't gotten our stuff. That was June 5th. The next day,
terminate appearance.
Rohrbach.
Well, I don't know. That's not that usual. Not that unusual. They just might be leaving the ASU's office.
He might be, which might explain why the discovery is getting passed over. But this is kind of starting to put this prosecution a little bit of risk.
Well, I mean, you're going to have to push the date back.
Yeah, and if they just keep not producing information, because the thing is, good for what's her name, Everdale. Good for her for filing that letter and keeping the court updated. Because if she were to ask right now to say government should be precluded from producing evidence, she's going to lose that argument. The court's going to be like, we're going to push the date. But if she keeps filing these notices saying, no, we've asked, then the judge might be inclined to say, we're not going to give you your continuance. You just can't produce it.
Yeah, squeaky wheel kind of thing, man. You make the record and be like, yeah, right. Zealous advocacy. Love it. Good job.
Yeah. So that's the update on FTX. That's where we are.
Here's the tip to the DOJ. Stop screwing around.
Stop fucking around. Just stop doing it. Stop doing it. So I will release a video on the PGA and Live stuff when the details about the merger get more ironed out. I wanted to cover that at some point.
Do you have any feelings on the fact that 3 months ago or whatever it is at this point, PGA is over here saying Live is immoral. They're immoral. Our golfers are immoral. They're immoral for taking Saudi money. They basically are complicit on 9/11 and now yay money. Do you have any thoughts as relating to that?
Dave Portnoy released a statement about Jay Monahan that I largely agree with.
And what did Mr. Portnoy have to say about the issue?
That Jay Monahan is a certain type of individual that is a piece of human excrement.
Mm-hmm.
Because he literally, God, now I got to play the video. I do have it.
I mean, you can't go out 4 months ago saying the golfers who are PGA golfers are immoral bastards for taking Saudi money and then take a whole bunch of Saudi money. How's that work? How do you work back from that?
It doesn't. Jay Monahan, RBC.
Also, if the Saudi government would like to invest in uncivil law, give me a call. Saudi government, best government. Put a little banner ad on the screen. Pretty good.
So Jay Monahan, the remarks on the RBC. Where was he? Who was giving? It was with Chambly. Give me 1 second.
I'm also willing to front for other governments that may be needing some good PR.
Well, Dave Portnoy came out and said, like, stop. This is a business decision. It's a business call. Why are you invoking 9/11?
Yeah.
In any of this? And when I'm now like kind of nervous when I play this. Hang on, Dave. Let's see if we can't find it.
Oh, yeah, the clip from a couple months ago where he said that in that interview. Oh, yeah, that's a good clip. That's basically what I've been paraphrasing this whole time.
No, I'm going to play that because
you should. You should play the original because it's basically what I've been attempting to paraphrase. So play the original.
And I don't think I've ever been as disgusted, like just period, because I have followed the Live and PGA stuff from the beginning. And when Live came out, I really wasn't. I thought the PGA was being really fucking hypocritical. They take a ton of money from people that are sports washing all over the world. And when they come out and say, you know, are you really going to back the Live League? It's like, well, you know, don't really say those things because you're not doing the best stuff in the world.
Stones and glass houses and all of that.
It's so much worse than that. God, where is it? Here we go. I don't know if I leave the tweet up when I do it because I kind of want to just echo the fact that I do agree with the sentiments.
We also have some requests for swoops. I feel like you owe the chat extra swoops now.
We can do a double swoop. Double swoop.
I love it.
All right, so I'm sharing the screen because my sentiments.
Oh yeah, this is good shit. So what is this, like 3 months ago, 4 months ago?
Yep. Not even. Yeah, 3 months ago, something like that. So this was at the Royal Bank of Canada. He was giving remarks, asking about Live Golf, PGA, etc. Listen to what he says. Oh, this is gonna make me so mad.
Let me ask about this. There was this.
Can you hear the audio?
Yeah.
Caveat. This is a question that is after Jay Monahan has been going out and calling the Live Golf League the Saudi-backed league 9 million times.
Which they are, to be honest.
They are. But I'm going to play a clip in a little bit that's going to make you guys even more pissed than you're going to be here. Yep. He literally just equated the Live golfers to the people that were responsible and or praised 9/11. There is no way of getting around that. And if to the extent you don't believe me on that particular point, then the merger gets announced with Live. And I will tell you, for those of you who have watched this channel, there are videos on this before. The PGA is a 501c6 not-for-profit entity that makes a shitload of money.
Also,
so much money passes through this entity that you could not fathom it. Yeah. But they have not-for-profit status because they are like the NCAA. They are the organization that...
Or the NFL. NFL is also a 501c6.
Yep. Well, Live files lawsuit against PGA. And the judge says, nah, not buying your motion to dismiss, PGA. So now we get to discovery. And Live starts propounding interrogatories, request for production of documents, and says, let me see the books. We get all the financials.
Are things done properly as a 501c6 should be?
Depositions get scheduled for everybody, and then all of a sudden, within a week, you see an announcement come through that the PGA is merging with Live.
Oh, that's convenient.
Not that they've settled their dispute, but that they're merging. And one of the terms of the merger is that the PIF, the players fund, which is the actual Saudi government fund, Live Golf is owned by them. The actual Saudi government fund is going to contribute all of their assets and money to the PGA and this new entity. And they're going to cooperate and form a brand new for-profit entity.
I drink your milkshake with a very long straw, is what I'm thinking.
It is so. And within the week, hang on, I'm getting a quick note. I got to read something. Hang on. Oh, hey, Mom. Mom sent a member chat. Love you, Rob. Love you, Mom. We're talking golf and I'm getting heated.
Also, hi, Rob, Dad. Happy Father's Day.
We're gonna wave up.
I know, but I thought it was a nice thing to say. I hope
that's appropriate. That's appropriate. We can wave up. Thank you. Actually, Kurt, that was very appropriate, and that makes me feel very good that you would say that. Thank you. That was very.
I thought that was I'm sorry if that rubbed you the wrong way. I apologize.
No, it took me half a second to realize that you knew exactly what you were saying, and it makes me feel that much better that you did.
Okay.
Thank you, Kurt. That was very impactful, and that actually meant a lot to me. So thank you very much for that. Yeah, I didn't think that would make me emotional, but it did. Thank you. So that was the announcement before the merger. So how many people have had to apologize morally for, playing for the PGA? Well, now the PGA has merged.
Well, as it turns out.
Oh, it gets better. It gets better. I gotta find this one clip. Here we go. Share this tab. Ready?
To organize and orient this in a way where, again, we're in a control position. We have an investor, a great and world-class investor, to organize and orient this in a way where, again, we're in a control position. We have an investor, a great and world-class investor.
A great and world-class investor.
Seems to be a little bit different than what he said before.
A little bit.
What happened to all those moral dimensions we talked about before? Did the Saudi government reformed morally in the last couple of months? Was there a massive change in Saudi government that I missed? Did the Saudi government become differently massively in the last 4 months?
No.
Things can change with money.
It is as bad as you think it is. And the letter that he released, hang on, here's the letter that was sent. Dude, everything about this guy, he needs to go. You can do a lot. There's a way to move beyond this. There's a way to reframe this, not after those statements. Not after that. Because you just can't do that. And when he was confronted on it, he literally said, I respect the confidentiality of the arrangement. I had to respect confidentiality. I was in conflict because I had to respect the confidentiality of the proceedings. Fuck you.
That's when, okay, if that's what he meant, then what he should have said was, before making that other statement, is I can't comment on it because I want to respect the confidentiality of it.
But he
You know,
didn't.
like
He didn't want to do that. He wanted to
but
take
that's
the
what I'm
moral
saying.
fucking high ground. He wanted to
Yeah.
take the moral high ground in the argument. He wanted to skew the deck against Liv. And you know what? You want to talk morality? The PGA's investors include a shitload of people who do a lot of really crappy shit. And so do Liv. They all do. Every one of them. Don't you, it's like just like politics. Don't you dare think that any one of them are saints or the right group. They are not.
Right.
They all take dirty money. When you get to that level, they all have it in that system. So when one of them accuses the other, the pot calling the kettle black, saying, you take this dirty money, and then invokes morality and invokes 9/11 victims to make their fucking point.
Yeah.
And then says the same people that were these terrible people that you should feel ashamed for waking up and playing on this league, they are now a valuable partner. Fuck you. I'm sorry.
Anytime you invoke tragedy for, for outrage like that, it's a source of high skepticism. I just, because that's also at the same time, 9/11 was 20 years ago. At some point when you have these big events that happen that are terrible, we are not walking around talking about how we're never going to be friends with Germany, for example. At some point, you can't keep pointing at something.
I'm not sure how apt the analogy is, because in both the case of Germany and Japan, the government somewhat changed. I'm not sure how true that is in Saudi Arabia.
Yes, I fully agree, Kurt. There are many ways to distinguish, but the overall point is how long are you going to be pointing to?
Well, we said never forget, right? So I mean, forever, supposedly.
But it's not that. That's not it. It's you don't get to take that moral high ground. Like you aren't doing this for business purposes. He wasn't saying that because he actually fucking believed it.
Yeah.
And I don't care. If you can come at me, I will. Jay Monahan, you're a piece of shit.
Was he going to sue you for defamation for saying he didn't really believe it? Well, I mean, his proof is in the pudding a little bit on that one.
He said it because it gave him fucking leverage. He said it because it gave him leverage. It gave him leverage in the political argument, the argument of the press. So, fuck you. You go out and you invoke that to gain political points when all you're doing is trying to kill the league that's coming up, right? Mm-hmm. You take the dirty money, but you want the public to hate them more and not think about the money that you take.
Yeah.
And then you merge with them. And it is a merger. I have seen all the reports. I've read it. People are like, oh, but the PGA knew what they were doing. No, it's a fucking merger. They were afraid their 501c6 was going to be just see you later. Because once the dollar figures got reported, then Congress starts investigating, say, hey, we should take a look at this tax code.
Yeah, good luck on that.
This sounds like sports ball.
A little bit.
Well, sports ball, it's corruption.
It's corruption.
It's golf, so it's only like a half sports ball.
Yeah. This is why I don't talk about politics a lot, because they're all fucking dirty. Every one of them. Every one of them.
That's why I'm voting Rob. 2024.
Oh, sorry. No, don't do it. This is
Rob,
why
vote right in Rob Morton for president.
No,
Rob, he'll bring the change we need.
This is why we need to go back to the model that elected George Washington. It was kind of like, we are just going to nominate somebody, and I don't care if you want it or not. You serve. Oh,
I need you to be present so you can nominate me to the Supreme Court, Rob. I have a little self-interest in this one. Please vote Rob.
That's pretty good. I like that. I saw Nicholas. Nicholas said that Ian, He got you to make a sports analogy on his stream. He had to look out the window for mushroom clouds. Oh, I didn't get to go back and watch the clip, but Nicholas had sent that to me previously, and I'm curious, what was the analogy?
I was talking about bullet spin from rifling and how it's akin to the spin you put on a football.
Totally tracks. Totally tracks. No.
Same idea. Yeah.
Okay. That's a good analogy. That's a fair analogy. All right. What do you say we swoop to more positive conversations and wrap up with some super chats?
Yes.
Let's do that.
Yes.
Kurt's timing is back. Time the live players should be apologizing. They're not going to. They're really not going to. And I know I get your position entirely that the players fund was sports washing. Sports washing, by the way, is basically don't look at the things my regime is doing. Look at the cool sports things that we're doing and the charity we're doing under that sports ball stuff. Don't look at how nasty the regime is. They're not going to apologize. They're not.
Is the PGA going to apologize to live golfers now? They're the same thing.
Every government in the world, in the history of the world, has done something. You know, like not
and
to
is
say
doing
that
something
everything
right
is equal.
now.
Not to say that everything is equal, but like, you know, if you dig just enough, you'll probably find something that outrages you.
Yep. And time I see here that I don't agree that Liv should be joining the PGA. They're not joining. The PGA made the voluntary choice to, I think, lose any moral high ground they had by saying we're going to merge with them.
I suppose DOJ could always file an antitrust.
Oh, you mean like they already have, which could tank this deal in 2 seconds?
No, maybe DOJ wants to take a look at the books.
Oh no, they already have. The FTC is already investigating. So this can get crushed in a second, because what's more anti-competitive than the league that was suing the other league for anti-competitive practicing merging with each other?
But it's sports ball, so it doesn't matter.
When it's that much money, buddy, it does. When it's that much money.
How is there that much money in golf?
Time. I'm not trying to make this a geopolitical discussion at all. What I'm saying is that this was hypocrisy at a massive level. Thank you for the super chat, and thank you for engaging. Honestly, your questions and commentary has been great. I'm not getting into the politics behind either government, but the hypocrisy of the PGA chair to say, do you have to be ashamed to play for the PGA? And then calling the Saudi government wonderful investors within months of each other and invoking 9/11 in the process.
They do have a big pile of money.
I would say that's kind of why I kind of think that Jay Monahan is a special class of individual. Nicholas, thank you, my friend. I take unknown ways to launder money for $500, Mr. Trebek. We've covered a few of those today. Marble Cat, thank you. Rob, is this the same Leslie Stewart who was arrested trying to enter the U.S. from Canada? I don't know.
That would explain a lot.
Steve A. Leslie Stewart has had previous insurrection interactions. He's sued in the past for not getting a visa. Stewart versus U.S. government, Southern District of Florida.
Good luck.
Must be.
Good luck.
So he just wants to get in via the bankruptcy.
And also get $1.5 billion out of nowhere.
In statutory damages, yes.
I would like $1.5 billion.
So just,
Many people would.
Sue the government and say that they should all be arrested for fraud.
Is it too late to file as a creditor?
You can. The bar date has been extended, so you can still look that up.
All right.
Please give me $1.5 billion. But maybe don't send that as a super chat. Send that via.
Actually, I don't
then
even
YouTube
care
will take a cut.
I don't even care if YouTube takes 30%. That's fine.
I don't think Google gives a
$1.5
shit
billion
either.
will be fine. That's fine. Give Google $200 million. It's great. I don't care. It's
Maria
fine to me.
Sophie. In Australia, notary public are SNR legal practitioners qualified to authenticate, prepare, verify, witness, and certify legal documents for use internationally. Thank you for that. Caitlin Moore, thank you very much. Pretty sure the crochet clam is a finger puppet. If the crochet clam is a finger, oh shit.
You're going to have to put your fingers in the clam?
Show us the proper technique, Rob. How do you do it? What's the proper way?
I am so glad that secondary swoop is gone. It's not even an option to come up.
Yeah, no, I'm sad because now I'm going to... Oh, there we go. Hey, look, it's got a pearl in that clam. I might need that other swoop. Put it back.
You don't get it. You don't get it. Oh, sorry. Sorry, it was too funny. Okay. Oh God. Now I need George Takei's "Oh My" meme. That was a lot. Time, Rob, you deal with Canadian wildfires in your area. We had them. They slipped through. Probably.
I made them go away when I landed.
Yeah, like Alita landed
I haven't smelled
yesterday.
I haven't smelled anything.
They were bad the day before. They have.
Are you sure it's not COVID?
Down. It's cooled down quite a bit too, so I think the air has passed through. They're not that bad. New York was terrible though. And then time again, Ian, what kind of beer did you find in Ontario?
It's just a Stella. It's not fantastic, but I mean,
it's a good, solid, standard choice.
It's tall. It's good. I mean, it's not like top shelf, but it's solid.
Time again. The only time I watch golf is when I want to sleep. That's fair. Some people do that. That's okay. Stacy Walpole, thank you. Have either of you read or seen Judge Olmedo's written judgment on Masterson's lawyers? It's interesting if you haven't yet to read it. I haven't seen that yet. This is Danny Masterson's lawyers? I'll have to look that up.
Yeah, it's
didn't they get chided for sharing information with the Church of Scientology or something?
I saw something about
it was confidential information about the victims and like addresses and all kinds of stuff.
So
Tom Mesereau, the former lawyer, and then someone else that I didn't recognize from before, they both got sanctioned, but they got sanctioned like $950. That's what the fee. So the prosecution was asking for $1,000, which is the minimum to report to the California bar, and the judge ordered $950 per person, and they're appealing it.
Did you know that Napster is still a thing?
Yes, but not for good reasons.
I don't know why I just thought of this.
Also, LimeWire is still a thing, and don't go on it.
Well, this was this.
I haven't used LimeWire in a hot minute.
And this is kind of ADHD brain. I don't know why this just happened, but I had this.
Yeah, it does sound like it.
It does. It was this. The attorneys in this case Napster. Class action plaintiffs lawyers are now officially on notice. If you're litigating the Ninth Circuit, you better not expect to be paid more than your clients get. Napster class action litigation. The litigation resulted in a couple $1 million, but it would have paid out $53,000 to the claimants, and the attorneys wanted $1.7 million.
That sounds a little suspicious.
Yeah.
I mean, sometimes the attorneys do work, and sometimes there's not a whole lot of cash, to be had. But
that sounds like almost fraudulent at that point. It's like,
I don't know. It depends on how much work. It sounds like the judgment itself was a turkey, right?
Yeah.
So I don't know. I don't know.
It's this part. It matters little that the plaintiff's counsel may have poured their blood, sweat, and tears into a case if they ended up merely spinning wheels on behalf of the class. What matters most is the results of the class members. I kind of like this opinion because I hate the class action litigation for only the attorney's sake.
Yeah, I mean, the thing is, a lot of class action litigation ends up not helping most members of the class. You know, you get like, hey, you are a member of a class. You're entitled to $7.85, or you're entitled to a voucher or something like that. And
to be fair, a lot of times those class members don't even realize that they have a claim to begin with. They never would have brought anything. They never, you know, like they also haven't expended any time for it. So it's like they don't end up getting like a lot, of course, but like an argument could be made that in a lot of these cases, probably the majority of these cases, they're getting more than they would have otherwise.
And I mean, a lot of the time it's more that that this is a way that we discourage bad actions by big companies. Because
I get that, but it's also the bad actions that's why class actions exist, because the bad action was enough to affect a whole class.
Yeah, and I mean, you've got one person suing over $100 claim. The company could just bury those people one after another. But when it turns into a $1 billion claim because there's a ton of people each with that $100, suddenly the company's like, oh, maybe we should stop doing that thing that is screwing over everybody. Now, I mean, class actions vary from ones that I look at and I'm like, hey, that's super relevant and super, you know, that makes a lot of sense, to ones where I'm like, oh, really? That's your claim? Because sometimes the claim, like, that's the other problem, is that sometimes class action claims can be for injuries we might consider trivial. Like the one with McDonald's where it was like you didn't realize that the fries were not vegetarian. But they didn't advertise that they were vegetarian, and you're in a McDonald's.
Yeah.
Like, just every time you step into a McDonald's, you should assume that they're shooting a cow somewhere. Like, that's your door prize for walking in the door. But so I was just like, I don't know. There's that, and I mean, there's that one that's not going anywhere where the guy is suing like buffalo wings.
They're not made in Buffalo. Or of Buffalo.
No, they're not
wings.
What is it?
Actual buffalo.
They're not actual wings.
The boneless wings are not wings because they're not.
Yeah. Oh, they're not actual wings that were deboned. They're just breast meat formed into, and it's like, okay, really? That's your suit? Now, to be fair, that guy is a serial filer of BS suits.
Uncivil is starting to fade very fast, so Uncivil inquires how much more we have to go because Uncivil.
Speed round for 11 more.
All right, hold on. Let's speed round.
Okay, speed round. Jessica, thank you. Check your darn Twitter DMs, bro. Just stopping by to show some love and say hello, Jessica. I have been off Twitter all week. It's been a psycho week, but I get to those on the weekends, I promise. Heather, thank you very much. Is it normal to have a judge on a TV screen in a courtroom when the courtroom is that small? Surely they can see where they are. There were remote participants to the courtroom. There was a Zoom. You could see it in the background. So that happens. Elizabeth Walker, thank you. Congratulations. Shout out to Larry Gibbs for graduating college with honors. We are so proud of you. Congratulations, Larry. Way to go, bud. Now, get a job and stop being a burden to your parents. Just kidding. Congratulations. Enjoy it, bud. JR, Phil did the same thing, though. He did indeed. Analytical Blarney. I love how when Runkle comes back, Rob instantly calms. It warms my heart. No, Ian can push buttons and it helps. And I can only do that. Super chat or StreamYard lets me pick one person that can do that, basically. And
I think this came in when you were ranting, though.
Oh, okay. Then that. Because Ian doesn't get sports ball. Heather, so if we vote Robin as president, well, not me, as I'm not in the U.S., does that mean we can all then call the White House and ask for Rob?
Yes.
Oh, no. Chat told Kurt back. Kurt posted the White House switchboard as a phone number earlier. Do not call.
If you do become elected president, then I'm going to call you on your cell phone and then later be like, I just got off the phone with Washington.
No. Island, kudos to Rob's Wi-Fi for supporting both Rob and Alita all evening. The real MVP. I feel like we're in good stead for Lawyers and Dragons. I think we're okay.
We'll see how mine holds up.
This computer is hardwired in and Alita's on Wi-Fi. We're doing fine.
Yeah.
Nick Loss, with his finger, Rob brought this clam to his face. Jesus, Nick Loss. Susan Farias, not sorry. Nothing to apologize for, my dear. Kristen M96, wait, isn't there a clam puppet in the monkey book? I think there is. I am not pulling that out right now. Delia's Doodles, Rob, will you be putting some shine on that pearl? Nope. It is fine by itself. Kayla Gibbs, thank you for the super chat. And Weed, they already bailed. Why would they apologize? And they are winners. They would not be in this position if they hadn't been winning tournaments. So I think that's part of it. But we're going to wrap things up for the evening. Thank you to my guests. As always, 11:45, not too bad. 3 hours, 37 minutes. We are getting down there. Kurt, why don't you jump off? I am being reminded that I have forgotten gifted memberships. So why don't you jump off? It's a good transition period.
Good night.
Because I was being reminded emphatically, because even though YouTube has created a new chat window that lets you pull up gifteds and show what they are, StreamYard has not let me star them.
Yeah, that and member chats. They don't show up.
Yeah.
It's annoying.
So Jessica, thank you for the member chat. I finally made a nice wood toy box from scratch. Thank you. That's awesome. Thank you. Canonical Heat with gifted memberships, 20 gifted memberships. Thank you. Emily Gale, Free Zachariah Anderson. That case is awful. Misty Harris, thanks, Rob. There's nothing better on TV than this. Thank you for that. I actually am inclined to agree, regardless of whether it's me hosting or anyone else that shares a screen or my other friends are on YouTube. I choose to watch them more so than TV any day. Nicole, thank you for the gifted memberships. Robin, thank you for the chat. Whatever happened to Professor V TikToker? Professor V the TikToker.
Defamation
the
case.
professor, the Texas TikToker. Yeah.
I think that one's still working its way through.
The judge didn't grant the default.
I'd have to.
I don't know. I know Emily's been covering that, so I would check in with her because she's been covering that pretty closely. Melissa Harden, thank you for the member chat. Thanks to FNF, I got 2 screaming goats. Goat riots, indeed. Lady Drake, thank you. Gifted 10 memberships. Thank you very much, Lady Drake. Tina KS Nerd, thanks, Rob, for always making my Friday nights. Thank you for being here, Tina. Jessica, that is repeating because that was the end of that one. Boy Mom, thank you. Lima, careful of glitter at Ghost Blade's house. Don't tip her off for anything. Tubby Tilly, Luna was Ravenclaw, by the way. She was. Stephanie, gifted 10 gifted memberships. Thank you very much, Stephanie. Amber, 10 gifted memberships. Thank you. Annabelle, 10 gifted memberships. Thank you. Equality with gifted memberships. Mom coming back again with the member chat. Love you, Rob. Love you too, Mom.
Now I feel bad about the clam comments.
Yeah, she heard first. Koru, sorry for the smoke. We're fine. Torin, thank you very much. Falling asleep, but wanted to thank everyone for getting me to 719. So
nice.
Torin had 698 and got to 719 while you guys were watching. Thank you guys for doing that. That's really appreciated. Rob, don't forget to answer the Discord question so I can start your braid. I will, my friend. Thank you very much. You guys, thank you both for being here. Alita, I'll see you in a minute. Ian is so jealous. Ian's jealous.
I'm a little jealous. I would rather be in Virginia than Ottawa.
Yeah, come on over. We can all have a good time. Thank you guys for being here. Thank you to the chat. Thank you to the mods for doing all that you do to keep the chat a great place to hang out. Thank you to my guests and go ahead.
I got to ask, is there Aladdin sheets on the bed?
No. No. Well, I have upgraded the sheets. There were Aladdin sheets. because that was niece's nephew's room. There were Aladdin sheets. There are now standard sheets. Ian's saying they're not as good as the sheets that he slept on. That's what he's saying right now.
You got to insist on the Aladdin sheets. Oh, it's not the full experience otherwise.
All right. Good night, all. I hope you have a wonderful, happy weekend. Get out, enjoy the weather if you can. And thank you again to my guests. Uncivil, please go check him out. Runkle of the Bailey, check him out, especially on Monday. He does his Monday Fun Day. Alita, Legal Bites, go check out her content as well. She's been putting out videos. She's been doing more video on demand, which are great because they're just good content, guys. Also, Alita does members only on Fridays. Great hangout there. It's fun. And then Ian and I do members only live streams for Trials of the Century. And the next one, can we announce that yet? Yes.
I think so. I think that was the 28th.
28th.
Yeah. So after my factum is due, it'll either be done or it'll be in. It's one of those. Well, it's going to be in. The question is whether I'm happy with it and whether it's like officially done. Will be a second question, but that means that we'll be able to talk about it. We're covering a case that I think is really important, but is also kind of weird in terms of its legal twists and turns. It's Donahue and Stevens.
It involves a snail.
It involves a snail.
That's all we're going to say.
This is the origin of being able to sue companies for making bad products.
Oh. That's fun.
It's where all this starts, and we can talk about just how important this case is because it's a British case, but that principle, because it has been applied in everywhere else. So, yeah, it's an important case.
Yep.
Interesting. I also have Menendez Mondays, I should say.
Yeah, Menendez Mondays. Yes. Classic trials.
Yeah.
Menendez needs to be. I'm waiting for the TOTC for that. When you wrap Menendez, I think
which might be like 5 years from now because it's so long, and I'm doing like 3 to 4 hours a week.
It's a long fucking trial.
I'm trying to do an experiment, and I don't know how it's going to work. There's an AI thing to turn speech to text, and I'm trying to see if I can figure out an efficient way, which is the problem, to do like some Canadian trials and turn the transcript into like different voices, like that are AI voices, because we don't film our trials. The only way to look at them is with the transcripts. So that way it would be like, hey, here's these voices, because otherwise it'll just be me reading a transcript for like, in some cases these trials are long. So that I think would be good, but yeah,
you gotta share that with me. So yeah, Trials of the Century, the members only is going to be the 28th. So that is the members only behind the scenes, the show prep. So if you have a gifted membership or have a membership to either my channel or Ian's channel, they are simultaneously streamed. We do a full prep show to kind of go through how we're preparing the actual live stream, and then the next week we do the live stream. So you get behind the scenes for the week prior, and then the next week you'll get the actual live stream for the Trial of the Century. So yeah, that's how that'll work. And then I will see these two tomorrow morning at 10 a.m. Eastern on Richard Hoag's channel for Lawyers and Dragons. Don't miss it.
10 a.m. tomorrow. Sorry, I couldn't help myself.
I know.
And this has partially been a test so that I could just make sure that I could actually function. Looks like I'll be able to.
Camera's great, by the way. Is that a new camera?
This is the camera from my garage. So it's a Logitech Brio that I brought out from my garage. I need to get a different. It doesn't work. Normally, this is the one that like points at my workpiece, and I don't think it works very well for that because it doesn't.
It's a good highlight camera. It's not a good low light camera.
Yeah, I need to get a better camera for like focusing on the actual leather work that I'm doing. So that'll be. I got to do some research on that. So.
Yep. So. It's a good place to leave it. Thank you guys for being here. Very much appreciated. Good evening to all of you. I'm going to hit the end button. Good night. Great weekend. We'll see you in the morning.